Good morning, everyone. Hope everyone's doing well this morning. Let's see, it doesn't look like we have anyone in courtroom two as of yet. So as soon as we have people ready to go, we'll get started this morning.
Good morning, Your Honor.
Good morning, Ms. Fogg. Hope you're doing well this morning.
Thank you. I am. I do have one announcement. Miss Lewis was kind enough to point out to me, and I overlooked this. The position 42 does not have any add-ons. The other remaining cases have already been resolved. So only the position that's on the calendar, not any of the add-ons I added on, are being addressed today.
Okay, very good. Thank you.
Thank you. And PD Vigiletti, I have responded, I believe, to all the emails that you sent this today.
Yes, I just saw that. Thank you.
Thank you.
Okay, courtroom two, we'll be ready whenever you all are. So you just let me know.
Yeah, we're ready in quorum too. I just want to make an announcement that
Okay.
I'm gonna do separate groups because it's only one deputy in a quorum, so.
Okay. So good morning. Just bring up whoever you have first.
Okay. I have with me Mr.
Good morning, Tom guys. Here.
Yes, Norris Henry.
Your Honor, in Mr. Henry's case, I'm going to ask the court for one last reset for approximately a week. He has three cases, one of which is in Clayton County, Georgia. It is also the same charge, the same alleged victim. And we feel it would be, while not absolutely necessary to advise them, we feel it would be useful for us to read that police report. The family's been trying to get down there and get it for us.
What position are we talking about?
This is
Henry?
position number 22.
Right,
Thank you.
so I'm gonna ask one last time for a reset for that. He was reset to today.
Okay, so Mr. Henry will be reset until next Tuesday, 7/23. Hopefully you can get everything resolved by that time, Mr. McLean.
Thank you. Yes, it has to do with the counter offer we're gonna make. Thank you.
Okay, very good. We'll see you back next week, Mr. Henry. Good morning.
Be good. We'll see you soon.
Who do we have next?
Your Honor, there's number 39, Mr. Shannon. I don't think it'll take very long to speak to him prior to our court session. It was just one count and the offer's time served bell suspended.
Because I just call you up and I wasn't ready for that announcement.
Okay, is he in the courtroom with you?
I think he is because I see 3 orange uniforms. I believe he is. Is Shannon behind?
Yes, yes.
He's one of those people. That will just take about 5 minutes to have an announcement, or less.
As you speak with him, can we go to someone else?
Who else? Do we
I don't have
have?
anyone.
All the inmates in courtroom 2, your clients, Mr. McLean?
Yes, but I have Miss Vigiletti's client, position number 11. It's
Okay, so why don't we take that position while Mr. McLean speaks with his client?
Shannon?
Brown. Shannon back there. Yes, in the blue chair.
This is who?
Shannon, Roderick Brown.
It's my understanding that Ms. Vigiletti, you needed a 1-week reset on Mr. Brown also?
Yes, Your Honor.
Okay, so Mr. Brown will be reset until 7/23 also.
Okay. Now,
Let's see, and just for some housekeeping matters, does the jail get Ms. Vigiletti's announcements?
yes, we do.
Okay,
We
so
got-
there are a number on that, that have, they're indicated that she doesn't need to be brought, or Mr. McLean doesn't need to be brought, so we
Yes.
can just check those.
I skipped over that one.
Okay. Anyone else that's Ms. Vigiletti's or Ms. McLeod's client with you?
Yes, but I have to pull them out, so just give me a second.
Okay, just let
Morning,
us
Your
know.
Honor.
Good morning, Ms. McLeod. While I have you, Ms. McLeod, there were a number of conflicts from last week that we had need for a conflict attorney. Did you get requested on those cases that are on the calendar too?
I was requested, Your Honor. I did meet yesterday with Mr. Belcher, Mr. Andrew Williams, and Mr. Zion Harper, and Mr. Gary Grace, who were all conflicts, Your Honor. And I also have Mr. Dontavius McCrary. And I have a client who is in ACDC. I haven't spoken to her, but I've spoken to everyone else already. So I do know what we're going to be doing with all of the people I have named.
And the one that's at ACDC, is that 40 and 41 more Queen Shirley?
Yes, Miss Shirley. That is
Okay.
correct, Your Honor. I haven't been able to speak with her yet.
Okay, we'll allow you to speak with her once they get on. Okay, let's see. The court will be in recess until courtroom 2 is ready to proceed.
Your Honor, we can go ahead with Ms. McLeod's client, and that is position number 27 to 32, Mr. Dontavius McCary.
What are we doing with Mr. McCrary this morning, Ms. McLeod?
Good evening.
Your Honor, we will be trying to see if he can get a bond.
Okay. Good morning, Mr. McCrary. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Okay. So who do we have on? Oh, Ms. Tyson, good morning. Can you give me Mr. McCrary's history, please?
Good morning, Your Honor. I'm trying to pull it up. 1 second. Coming up really slow. Give me 1 second.
And as you do that, can someone give me the bonds that are set? Well, did he miss court, Ms. Falk?
Yes, Your Honor, he actually has several failure to appears. Failure to appear with a $4,000 cash bond, a failure to appear with a $1,000 cash bond, and a failure to appear with a $3,000 cash bond, a foreign hold with no bond, and then a $7,000 surety bond on $7,500 surety bond on 24 SC 000757. The failure to appears were on, and I can actually pull those bench warrants for Your Honor. That was on 21 CR 00614134E. That was in Judge Morrison's courtroom. It looks like there was also a bond surrender from Jet Bonding Company. Oh, that was on his felony case that they surrendered his bond. And then let's see, there are some additional warrants here as well. 23 CR 008371E signed by Judge Morrison, 8515E signed by Judge Morrison. Those were signed on May 14th of 2024. So it is several different things holding him. We would ask at this time the case be reset to Judge Morrison's courtroom. She has, it looks like, quite a bit of extensive experience with him in bench warrants, and we would ask that those bench warrants all be addressed before Judge Morrison.
Ms. McLeod, that's my normal practice, and given that he has so many with Judge Morrison, I would be inclined to let her lift those bench warrants if she chooses to do so.
I understand, Your Honor, but I just wanted to say that I looked, and it seems to me that the bench warrants, based on my discussions with my client and my own research, he tells me that he actually was in court on the date in question with Judge Morrison, and he was told that he had a hold out of Cobb County, and the deputies came and got him. So he was actually there, but the deputies took him out of the courtroom saying that he had a warrant. So he did, in fact, appear in court. So those FTAs should not really have been in place. I do see that he's on the jury trial calendar in Judge Morrison on his cases on the 15th of August, that she has him set down for jury trial. That was what I saw this morning.
Okay. And if all that's the case, then she would be best in the best situation to handle that because she would know her jail calendar and possibly will have made notes that he was or was not there. So I'd feel more comfortable if it goes back to Judge Morrison. So Mr. McCrary, your case will be reset for the judge that issued the warrants, and you'll get notice of your next hearing date, sir.
Thank you, Your Honor.
Yes.
You can go ahead and go to position 39, Mr. Michael Shannon.
Is Mr. McLean available?
Yes, Your Honor.
Okay. Mr. McLean, are you with me?
Yeah, he's coming. He's just explaining some to
Oh.
another inmate. He's coming.
Okay, thank you.
So you want to do that?
I'll pick your charges now. Is it safe to expect that the judge will then assign me current served and that I find myself exiting this moment, that I find myself exiting?
Okay, Mr. Shannon and Mr. Goodwine are both ready, Your Honor.
Around, Mr. Chairman.
This is Mr. Shannon. Are we still on mute?
No.
What are we doing with Mr. Shannon this morning, Mr.
This is a
McLean?
negotiated plea, Your Honor.
Okay, good morning, Mr. Shannon. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to receive, the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can place your hand down. Thank you. Courtroom 2, your camera's a little high. I'm not sure if people need to scooch back or lower the camera so we can actually see. I can only see the top of Mr. McLean and Mr. Shannon's head.
That's good.
Okay, that's a little better. Thank you.
Better.
Yes, Ms. Falk.
Yes, Your Honor. The state's recommendation on this case is time served, 86 days, credit for time served, 43 days. That's going to be from May 30th, 2024 to today and close. That's all for the state. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
For said purposes, we do so stipulate. We've been over the plea statement in detail, and he asked the court to accept his negotiated plea.
Okay. Mr. Shannon, it's my understanding that in case 24 CR 0045554J, you wish to plead guilty to criminal trespass. Is that correct?
Yes, Your Honor. Yes, Your Honor.
Were you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, yes, I am, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, I am, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
Okay, I'll accept your plea as negotiated, Mr. Shannon. Good luck to you, sir.
Oh, thank you, sir.
You're welcome.
Thank you.
Next, we go to position number 16 and 17, Mr. Marcus Goodwin.
And what are we doing with Mr. Goodwine this morning?
Negotiated plea, Your Honor.
Good morning, Mr. Goodwine. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
I do.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down. Thank you. Good morning, Ms. McConkey.
Good morning, Your Honor. How are you?
I'm doing well, thank you.
The state's recommendation is 12 months served, 52 days, credit for time served, 26 days, balance probated, no further contact with Audrey Jones, stay away from Central Library located at 126 Carnegie Way, Atlanta, 8 weeks anger management, 40 hours community service, and no firearms. And that was for count 1, the simple assault. For count 2, the state's recommendation is 12 months to run concurrent with count 1 and a $300 fine. For count 3, the state's recommendation is 12 months concurrent with count 1, no further contact with Quanisha Nix, and the state will move to no pros position number 17 upon this plea. And the state would ask that the defense stipulate to venue, factual basis, and identification for purposes of the plea.
For said purposes, we do so stipulate. He asks the court to accept his negotiated plea. Your Honor, we would also ask that it go to non-reporting or terminate as soon as he does the 40 hours of community service and does the eight anger management hours.
Okay. Mr. Goodwin, it's my understanding that in case 22 CR 004120E, you wish to plead guilty to simple assault, willful obstruction of a law enforcement officer, and terroristic threats. Is that correct?
I do.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
I'm more than satisfied.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
I do.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Goodwin. As soon as you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't have to be on actual reporting to probation, and you won't have to pay those fees, okay?
Thank you kindly.
All right, good luck to you, Mr. Goodwin.
Next, I'm about to pull out Mr. Osborne, position number 35.
Osborne.
Okay.
Osborne. That is a non-negotiated plea, Your Honor. The issue is simply jail days.
Good morning, Mr. Osborne. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. Can you raise your right hand for me, sir? Do you swear or affirm the testimony you're about to give before this court would be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, thank you, sir. Ms. Tyson, may I get the history, please?
Yes, Your Honor. There's 28 arrest cycles beginning in 2014. Last arrest was in Spalding County. May 28th of 2024, and that was for a violation of probation. Here's a second violation of probation from 2024. There's a failure to appear 2023. Here's a felony conviction out of DeKalb County for, it's like 2 counts of felony terroristic threats and acts. Position date on that case is 2023. He received 1 year confinement, 4 years probation on that case. Here's another misdemeanor conviction out of Henry County for battery. That's from June of 2021. Here's another misdemeanor conviction out of Flint Judicial Circuit. One moment. Flint Judicial Circuit. For criminal trespass, disposition date on that case is November of 2020. Here's another misdemeanor conviction out of Clayton County for criminal trespass, and that's from June of 2020. Here's a misdemeanor battery out of Spalding County. That's from August of 2023. I apologize for that being a little bit out of order. Here's another misdemeanor conviction for battery out of Spalding County, and that's from August. I'm sorry, that's the same one. They just have it listed twice.
Actually, pretrial.
No, they don't. They don't. Yeah.
Yeah,
It's a
they
separate
don't.
case. It is. Okay, yes, it's a separate case. So the charges on that case is battery by shoplifting, criminal trespass, and that's also from August of 2023. Here's another misdemeanor conviction out of Clayton County for possession and use of drug-related objects. That's from April of 2020. He has a parole violation from 2019. Another misdemeanor conviction out of Henry County for misdemeanor willful obstruction, marijuana possession less than 1 ounce, hit and run, duty of driver to stop at or return to scene of accident. Position date on that case is January of 2019. He has another misdemeanor conviction out of Locust Grove Municipal Court, fleeing or attempting to elude police officer, marijuana possession less than 1 ounce. That's from February of 2018. He has a felony conviction out of Henry County. And that's for purchase, possession, manufacture, distribution, or sale of marijuana, willful obstruction of law enforcement officer, and 2 counts. Position date on that case is March of 2017. He received first offender treatment on that case, and his first offender was revoked February of 2019. He received 5 years probation on that case.
Okay, thank you, Ms. Tyson. I appreciate it.
Mhm.
Yes, Ms. Falk.
Yes, Your Honor. So this happened on May 23rd, 2024. Aisha Floyd was the victim in this case. She stated that she was waiting at the Vine City MARTA station here in Fulton County, and the defendant reached out to her, walked up to her, and grabbed her buttocks. The officers were able to pull the MARTA and the CCTV footage. They could see the defendant have ample amount of space to move about, but he squeezed between the victim and a trash can specifically to grab her. They were able to see who the defendant was. And put a bolo out. The defendant was actually identified from a past bolo for an aggravated battery and had a permanent ban from MARTA at the time of the offense. And so that's how they identified him. The defendant has, as you've heard, a number of battery convictions previously within the last 5 years. He got a 24-month consecutive sentence for battery, 24 months probation out of Spalding County in 2023. He then, on his criminal trespass in Clayton County in 2020, got an 80-day confinement sentence. He also received on probation violation in 2020, a 10-month confinement sentence. His battery in Henry County State Court, he got a 6-month confinement sentence. And the reason I'm pointing all this out, Your Honor, is just to show, Your Honor, that the state's recommendation is actually quite reasonable, in line with not only his history, but the amount of confinement time he has served previously on his cases. July 6th of 2023 was his most recent sentence, and that was a 5-serve 1-year sentence for terroristic threats and acts. And that leads us to the aggravated battery that was actually dismissed, which led to his MARTA ban and probation violations as well. And so that brings us to this most recent event where he grabbed a woman inappropriately that he did not know. The state's recommendation on this case is a 12-month serve 120-day time, credit for time served 16 days, balance probated, no further contact with Aisha Floyd, 40 hours community service, and we're asking for an SDET. We're also asking for a stay away from MARTA based on the permanent ban that already exists. Again, Your Honor, based on his previous history, he has at least 3 batteries in the last 5 years, as well as the terroristic threats. We believe our recommendation is quite reasonable and is actually lower than the most recent confinement sentences that he has served. At this time, we would like to sound for Aisha Floyd, and we would ask the defense to stipulate to venue, factual basis, and identification for the purposes of this non-negotiated plea.
Floyd is on the line and wishes to address the court. Now is your opportunity to do so. Mr. McClain.
Your Honor, for the purposes of the plea, we do so stipulate the 120 divided by 2 would be 60, minus 16 would be 44 extra days. And he wanted to ask the court to consider less than 44 extra days. He understands the SDET requirement, and we've talked about where to get it. And we would ask the court to let it go to non-reporting after he completes that SDET. The 40 hours of community service, same request. But on the 44 days, basically he's asked me simply to distinguish the facts compared to other things and ask the court to consider something less than the 44 days, such as cutting that in half, or that would be 3 weeks. That'd be 22 days right there. Thank you.
Given his history, I'm not inclined, I'm inclined to accept the recommendation of the state. And also given his history, I'm inclined to have him report in probation for the entire 12 months.
Understood. We're going to stick by the plea, Your Honor. We discussed that possibility as well.
Okay. Mr. Osborne, it's my understanding that in case 24 CR 004328C, you wish to plead guilty to criminal trespass and one other misdemeanor offense. Is that correct?
No.
Was that a yes?
Do I get the 44? Is it 44 days or?
Yes.
Okay, yeah, yeah.
So my question to you is that you wish to plead guilty to criminal trespass and one other misdemeanor offense. Is that right?
Yeah.
Are you under the influence of any drugs or alcohol at the present time? Say it again.
No.
You've been represented by counsel. Are you satisfied with his representation?
Yeah.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yeah.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept your plea, Mr. Osborne. The court sentenced for the criminal trespass, 12 months to serve. Well, for the second offense, it'll be 12 months to serve, 120 days, credit for time served, 16 days, balance probated, no further contact with Alicia Floyd, 40 hours of community service, and SDET. For the criminal trespass, it'll be 12 months probation to run concurrent with count 2. And given that you have a permanent ban from MARTA, you can't go back to MARTA.
Yeah.
You're gonna be on probation for the entire 12 months. Mr. Osborne, I'm going to waive 2 months of the probation fees so that it'll give you time to get a job and get on your feet if you don't have one. Good luck to you, Mr. Osborne.
Thank you.
Next, I'm gonna pull out position number 42 through 43, and that is Justin Smith.
Yeah. Sitting off the picture. This is.
Good morning, Your Honor.
Good morning, Mr. Ty.
Hey, the other one. You go to the where John?
And is this the one that we're only proceeding on one count, or is that another case, Ms. Falk? I'm sorry.
This is that case, Your Honor.
Okay, so we're proceeding on case 23 CR 006726H, the simple battery.
That is correct.
Okay, and is that, Mr. Ty, is this negotiated or non-negotiated?
Well, Your Honor, I'm sorry that my announcement was unclear. But I actually did, he does want to plead not guilty to position 42, but he's not being held on position 42. He's only being held on the failure to appear. His attorney has already, in that case, has already made a motion to set aside the bench warrant. And I would ask, and I don't know when that can be resolved, but I would ask today to just address position 43 and request to set aside that bench warrant, or like the bench warrant. He has a trial set for August 5th on position 42.
Is this Judge Morrison's case also?
Your Honor, this is actually before Judge Taylor.
Judge Taylor?
Judge Taylor, yes.
Okay. And as you know, Mr. Ty, my normal practice is to send it back to Judge Taylor's courtroom. Is there a reason that I shouldn't follow my practice in this case?
Yes, Your Honor. Well, okay. So this incident occurred November 27th, 2021, and my client actually spent February of 2023 until December of 2023 in custody here for 288 days. So he never had, I mean, really, I feel it should have been brought up at that point. He did have a hold in South Fulton. So, I mean, if he spent 288 days here after this incident allegedly happened. And in addition, I do want him to have the opportunity to move forward with the trial that's set on August 5th. He's not going to miss that date. He knows of it right now. He has a good address. And there are issues of facts which he needs the opportunity to present. And I don't want him to have to sit in jail just on the FTA to have that opportunity.
Well, if you petition Judge Taylor's clerk to put him on a calendar prior to that time, I'm not understanding what the failure to appear has to do with the 288 days that he missed back in while he was in 2021. The failure to appear was much later, right?
Yes, Your Honor.
That is correct,
He
Your
did not, and in that motion, his attorney stated that he didn't get notice of the court date on I don't know when it was. I'm looking at this.
It was February 27th of 2024.
And he states, and his attorney states that he didn't receive notice for that, and his address has not changed.
And he had an attorney at the time?
Yes. Well, yes, I think so, Your Honor. Samantha or Sarah Armstrong.
Let me just let Judge Taylor handle it the way that I normally do.
Your Honor, so in that case, he doesn't want to stay in jail any longer. So if the FTA can't be lifted, I think it's going to be at least a couple weeks that he'll have to wait for that. I would then like to move forward with a non-negotiated plea.
And what would not be negotiated about it?
So he has credit for time served, 13 days, but I would state, it's our position that he did spend time in jail in 2023, 288 days. The simple battery was not part of that. He didn't receive any time served, but there was a South Fulton hold, which I believe is this case. So I would say with the 288 days, I believe he should have credit for 288 days. And in that case, we would ask for the balance to be suspended if it is a 12 months, 26 days, 13 days credit for time served, but just ask for the balance to be suspended. No further contact with that person is fine. And the 8-week anger management, I would ask for him to not have to do the 8-week anger management.
So given the change, let me just start at the top. Good morning, Mr. Smith. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, Mr. Smith. Ms. Tyson, may I have the history, please?
Yes, Judge. We have 2 arrest cycles out of the state of Georgia beginning in 2023. His last arrest was the FTA that's on the calendar. His previous arrest was in Atlanta, February 23rd of 2023, and that was for aggravated assault, burglary in the 1st degree, receipt, possession, or transport of a firearm by a convicted felon, possession of firearm or knife during the commission of criminal trespass, battery, family violence, 1st offense, simple battery, 2 counts, and theft by taking. Looks like the case the simple battery, at least the GCIC states that the simple battery family violence was dismissed November of 2023. I don't have any other information on the other charges. And it looks like he had 2 holds, the FTA and another hold out of South Fulton for a probation violation. That warrant was signed May 23rd of 2024. And he has 2 cycles out of Mississippi beginning in 2015. One of those cycles did result in a felony conviction for robbery. Let's see. Disposition date on that case is November of 2018. He received looks like a 10-year suspended, 5 years supervised on probation. Nothing to add, Your Honor.
Probation violation. What do we know what he was on probation for?
Let's see. One second. Let me go back. Let me check Odyssey. Let me see if Odyssey will tell me something else about that other case. 1 second, Your Honor.
And Your Honor, I have 2 additional convictions in Odyssey. One was on the 23 CR 001749H case, which was family violence battery. The defendant was convicted November 8th of 2023 in Judge Taylor's courtroom. The other case that we're showing as a recent conviction is 23 SC 186759. That was a conviction for burglary in the 1st degree, aggravated assault with a deadly weapon, family violence, terroristic threats, criminal trespass and damage to property, and possession of a firearm by a convicted felon. On that case, he received 5 years to serve, 300 days, commuted to time served, balance of. That was the 300 days that Ms. Attai is referring to that he spent in the jail, was largely on those cases, and as she accurately stated, was not on this case. And so the state can't give credit for time served on a case that he was not in jail on at the time. The jail's simply not going to calculate it that way. And so we are asking that the plea recommendation remain as said, considering he was recently convicted of aggravated assault, family violence. We think the anger management and family violence battery, we think the anger management is absolutely warranted.
Okay. Is it time? Anything further?
Nothing further, Your Honor.
Okay, if you'd like to plea, I'm going to accept the recommendation of
And
the
Your Honor,
state.
if I can sound, oh, Your Honor, if I could sound for Mr. Keith Hatchell as well.
Okay, Mr.
He's the
Hatchell
victim in this case.
Mr. Hatchell is on the line and wishes to address the court. Now is your opportunity to do so. Okay, would you like to proceed with the plea, Ms. Attai?
Yes, Your Honor.
Okay. Mr. Smith, it's my understanding that in case 23 CR 006726H, you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your plea, Mr. Smith. The court sentence is 12 months to serve 26 days, credit for time served 13 days, balance probated, no further contact with Keith Hatchell, 8 weeks of anger management. When you complete the anger management, I'll have the probation go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation and have to pay those fees. Good luck to you, Mr. Smith.
Yes, sir.
Good morning, Your Honor. This is ACDC. Before you
Yes,
is
good morning.
position 23, Ms. Tamika Hill.
Oh, sorry.
And good morning, Ms. Hill. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. You can place your hand down. Mr. McLean, it's my understanding that this is a negotiated plea. Is that right?
Yes, Your Honor.
Okay. Yes, Ms. McCoskey.
Yes, Your Honor. The state's recommendation is 12 months, served 30 days, credit for time served 15 days, balance suspended, no further contact with Lanicia Stinson, and stay away from the Friendship Tower Apartments located at 35 Northside Drive, Atlanta. I would ask that the defense stipulate to venue, factual basis, and identification, and also ask the court to sound for Ms. Lanicia Stinson.
Ms.
For the
Stinson,
purposes, oh, I'm sorry, go ahead.
Stinson is on the line and wishes to address the court. Now is your opportunity. Yes, Mr. McLean.
For the purposes of the plea, we do so stipulate, this is an apartment. She will stay away from that place, and that person named is simply an employee of that.
Okay. Ms. Hill, it's my understanding that in case 24 CR 0043644C, you wish to plead guilty to criminal trespass. Is that correct?
Correct.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Hill. Good luck to you, ma'am. We have next.
Probation's 1 and number 8, Ambrose.
How many items?
So 1 and number 8 on the regular calendar.
Probation calendar.
Your Honor,
Okay.
his name was flipped, and so, and the calendars are alphabetical, so he's on the probation calendar as position 1, position 8.
Okay, what other position is he on? Is he?
Position,
Just probation 1 and number 8.
All right, I'm confused because my number 8 is a Ralph Autry. The probation calendar, my number 1 is Ambrose.
and then stay on
That's
the
what we're
probation
talking
calendar.
about, position number 1 and position number 8 on probation.
But stay on the probation calendar when you're going to position 8.
Oh, okay.
Yeah, it's
Oh,
an
okay.
alphabetizing issue. Yep.
Okay, thank you. All right, good. And what is his last name?
Ambrose, Your Honor.
Okay, good morning, Mr. Ambrose. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, ma'am, sir.
Thank you. Good morning, Officer Allen. Where are we with Mr. Ambrose?
Your Honor, the defendant was sentenced for the charge of theft by taking. He was required to complete a theft prevention course as well as stay away from the incident location, as well as pay probation supervision fees. He's failed to report to our office. He's failed to provide documentation of the the theft prevention course. There's 268 days remaining on his case. He has been in custody since July the 2nd, 2024. Your Honor, we request that this defendant be allowed to continue on probation to complete the course.
Did you ready?
Yes, Judge. I talked to Mr. Ambrose yesterday, and he described a situation that I find very believable, which is that when he took the plea, he was verbally told where to go for probation and just never given anything in writing. And Mr. Ambrose does have a significant traumatic brain injury. He also has significant physical disabilities related to a car accident some years ago. I'm told he spent 2 full years in the hospital, one of them in a coma. And when he was released without anything in writing, he couldn't remember where to go, what to do, or, wasn't even sure how to take the steps for, figuring that out. And so it slipped his mind. At that point, he wasn't sure what to do. He put it in the back of his mind. We did speak at length yesterday about his ability to take the class, and we put everything in writing together. He knows step one is to go in person to the probation office. He has that address. They will give him a hyperlink to take the class. He tells me that there's no issue whatsoever with actually taking the class. He can get through the class. He can't rely on his memory for things. He does, as I said, have a significant traumatic brain injury, but he has everything in writing, and so I don't think we'll have this issue again, Your Honor.
How many days has he been in jail, this time?
He's been in jail since July the 2nd.
And he received credit for 7 days when he took the plea, Your Honor.
And so that's 14 days. So he's been in jail a total of 21 days?
Yes, Judge.
Okay. Given what I've been told, from Ms. Vigiletti, and that is a theft by shoplifting, and he's been in custody for 21 days, I'm going to give him credit for time served and close the case.
Thank you, Your Honor.
All right.
Thank
Good
you.
luck to you, Mr. Ambrose.
Next, we can go to position 19, Mr. Sterling Green. Michael.
And this is a negotiated plea.
Sterling Green.
Is Mr. McLean there?
Yes, Your Honor, he's right here.
Okay. A negotiated plea, Mr. McLean?
Yes, Your Honor.
Okay, good morning, Mr. Green. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, thank you. You can place your hand down, Mr. Green. Yes, Ms. McConkey.
Your Honor, the state's recommendation is 12 months served, 36 days, credit for time served, 18 days, balance suspended, and a stay away from all MARTA property. I would ask that the defense stipulate to venue, factual basis, and identification for purposes of the plea.
We do.
Further, Mr. McLean?
Nothing further.
Mr. Green, it's my understanding that in case 24 CR 004263B, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. You understand that you can't go back to MARTA, you understand that?
Yes, sir.
Okay, good luck to you, Mr. Green.
Thank you.
Who we have next?
Let's finish up with medical, Your Honor, and then can we come back to ACDC?
Okay, who do we
Thank
have in
you.
medical? You're welcome, thank you.
Position number 24, Ricky Ingram.
Okay. Mr. Ingram's going to be a non-negotiated plea.
Correct.
Good morning, Mr. Ingram. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, sir. Ms. Tyson, may I have the history, please?
Yes, one moment. We have 23 arrest cycles beginning in 1981. His last arrest was in Fulton County, January 2nd of 2024, and that was for a violation of probation. He has a misdemeanor conviction out of Fulton County for theft by shoplifting. That's from February of 2019. Had another misdemeanor conviction out of Cobb County for theft by receiving stolen property. That's from October of 2016. See, that's his most recent conviction. He does have at least, let's see, 1, 2, 3, 4, 5, 6 felony convictions outside of the 10-year period. The most recent was out of Fulton County for theft by receiving stolen property, possession of a firearm by convicted felon, and carrying a concealed weapon. That's from 2007, Your Honor. He has another from, let's see, 2004 out of Fulton County for possession of a firearm or knife during the commission of burglary and armed robbery. He has an FTA from 2003, 2002. He has another by receiving stolen property out of Fulton County from 2004. He has an enter auto from 89, another burglary from 87, and let's see, it's theft by taking and a burglary from 81. Nothing to add, Your Honor.
Okay, thank you. Yes, Ms. McConkey.
Yes, Your Honor. In this particular incident, officers arrived at the incident location 3110 Godby Road in College Park and met with 2 witnesses, Christian Hernan and Lakeisha Moore, who advised that they were asleep upstairs and were awoken by a commotion coming from downstairs. When they went downstairs, they witnessed the defendant beating the victim, Andrea Tabb. After being unable to break up the altercation, Mr. Herndon went upstairs to call the police. Upon arrival, officers did observe the defendant on top of the victim. The victim had swelling on both sides of her face, a busted lip, and her clothes and the floor were covered in blood. The attack was the result of the victim telling the defendant she did not know where his phone was, which caused the defendant to throw a cup at her and begin beating her. The last time our office had contact with the victim, Ms. Andrea Tabb, was the 26th of June, where she stated that her niece is the caretaker, and so she moved them upstairs in her home. So I'm assuming her niece is Miss Lakeisha Moore. The defendant stated that, the victim, stated that her and the defendant had been trying to get back together, and they were in a relationship about 10 years ago. She did confirm the events in the report at the time we spoke to her and stated she's afraid of the defendant. She also stated she sustained a black eye and busted lip. And she stated the defendant gets aggressive when he is under the influence of alcohol. She did state that she wants no contact with the defendant, anger awareness, and alcohol and drug evaluation, and of course, a stay away. The state's recommendation is 12 months to serve 180 days. Given the events that occurred, credit for time served 22 days, balance probated, stay away from that incident location, but we will allow a one-time police escort for him to get his belongings. No further contact with the victim, Andrea Tabb, ADET, and FVIP, 40 hours of community service, and no firearms. I would ask the court to sound for the victim, Ms. Andrea Tabb, if she is on the Zoom.
Tabb is with us and wishes to address the court. Now is your opportunity. Mr. McLean.
Your Honor, the issue for Mr. Ingram, he wishes to make an offer a non-negotiated plea to the court. And this would result in 68 extra days in jail. He would like to ask the court to consider something in the neighborhood of 30. He is disabled. He has worked in the past. Before he became disabled, he does not have part of one of his legs. He worked for the Joe Brown he went to Joe Brown High School. He worked for a construction company. He worked in landscaping, and he worked in warehousing. He understands his obligations to take the FVIP, the ADET, the 40 hours, et cetera, as a result of this plea. He would ask the court to consider non-reporting as soon as he finishes his requirements.
Okay, I didn't hear any violence in his history in the past 10 years or so. The court sentence would be 12 months to serve 90 days, credit for time served 22 days, balance probated with all the other conditions. If you'd like to accept that, Mr. McLean, then we can proceed. If not,
Yes, Your Honor, we discussed the range of possibilities for today, and he would like to accept that.
Mr. Ingram, it's my understanding that in case 24 CR 004157E, you wish to plead guilty to battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
I don't understand really. I'd like to know what I got to do. You saying I have to do?
That's 23 more days, Mr. Ingram. 23 more days, and then you go on probation to do that FVIP and the 40 hours.
What is my release date?
23 plus today, let's see. If the court will indulge me for a minute, he's asked this before on the release date. Today is the 16th. So 23 plus 16. August the what? Somebody shouted it out.
Yes, sir.
It'll be in 3 weeks. It'll be early August, probably the first week of August.
Okay, sir.
Thank you.
Mr. Ingram, my last question to you was, you've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept your plea, Mr. Ingram. The court sentence will be 12 months to serve 90 days, credit for time served 22 days, balance probated. Stay away from 3110 Godby Road. You can have a one-time escort to retrieve any belongings from that location. No further contact with Miss Andrea Tabb, ADET, FVIP, 40 hours of community service, and no firearms. Once you complete the terms of the probation, Mr. Ingram, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation. Good luck to you, Mr. Ingram.
Thank you, sir.
Next, we have position 40 and 41, Ms. Shirley.
I think Ms. McLeod needs to speak with Ms. Shirley. Is that not, do you, Ms.?
I have spoken with her, John.
Oh, okay, good. And what are we doing with Ms. Shirley this morning?
It is going to be a non-negotiated plea, Your Honor.
Okay. Good morning, Ms. Shirley. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. You can place your hand down. May I get her history, Ms. Tyson?
Yes, Your Honor. Looks like the defendant is a multi-state offender. She has 2 arrest cycles out of state of Illinois. First one was in 2013. Her last arrest was in 2018, July of 2018, for aggravated battery. Disposition is not listed. It just states that the case was filed August 7th of 2018. No further information was provided. She has 1 cycle out of Arkansas from 2016, and that's for absconding and obstructing governmental operations. No dispositions listed for that case either. Out of Georgia, looks like she has 7 cycles. Last arrest was in East Point, June 30th of 2024 for misdemeanor willful obstruction. No dispositions listed on the DCIC for that case, Your Honor. Let's see. She has one violation of probation from 2020. She has a misdemeanor conviction out of Fayette County for willful obstruction. That's from May of 2020. She has another misdemeanor conviction out of Fayette County for simple battery. That's from July of 2019. And it looks like she has a felony case out of DeKalb County for arson in the first degree. Disposition date on that case was February of 2019. She received first offender treatment on that case. And it looks like she received 6 months confinement and probation for 6 years and 6 months. So there's no seal date on that case as of yet, Your Honor. Nothing to add.
Thank you. Ms. Falk?
Yes, Your Honor. The reason there's no seal date on that first offender is because she was actually sentenced on February 21st of 2019, and the 6 years has not been completed yet on that felony probation on the arson. On the simple battery, she had received 12 months, the one out of Fayette County. On the obstruction case out of Fayette County Superior Court, she received 12 months to serve. And that brings us to her most recent case today. So the battery case happened May 28th of 2024. Officers spoke with the victim in this case, Miss Bruce. She stated she was asleep in her vehicle behind the business of HireQuest, which is at 1751 Washington Road, where they both work. Miss Stephanie Bruce stated that the defendant came over to her vehicle saying, "I know you stole my shit." Miss Bruce stated she stepped out of her vehicle, asked, "What are you talking about?" And then the defendant drop kicked her and she fell to the ground. She did have a visible injury to her right elbow. And they also stated that, let's see, there were not any cameras that recorded the incident. I will say we did have an opportunity to, let me see, speak with Miss Bruce. Her statement was that, let me just pull this up, Your Honor. Her statement was that they both work at the incident location. She did confirm the events. She said she barely knows the defendant and she felt like the incident came out of nowhere. She stated that they, after the incident happened, they were standing outside the business and the defendant continued to threaten her, and she wants no contact with this defendant. The second incident that occurred that is on the calendar on the battery case, due to her conviction for willful obstruction, where she received 12 months to serve, due to the previous conviction before that for a simple battery, both of which involve violence. The obstruction was actually pled down from a felony obstruction. We are asking for 12 months served, 60 days, credit for time served 20 days. That's from 5/28 to 5/31 and July 1st, 2024 to today. Balance probated, 12 weeks of anger management, stay away from HireQuest at 1751 Washington Road in East Point, and no further contact with Miss Stephanie Bruce. That leads into the second case, which was the willful obstruction and the loitering. That happened approximately a month after the first case. So this happened in June of 2024, June 30th to be precise. And the defendant was loitering outside of the business at Sherwin-Williams. That was at 1797 Washington Road in East Point. She was observed by 3 individuals sleeping and lingering in front of the store. She was given commands for identification and was unruly, not cooperative. And finally, she was taken into custody. The incident involved the willful obstruction was just for her not complying with the lawful orders of the officer. I do not believe she tried to institute or engage in any violence with the officers. She just was told multiple times by the officers to calm down and not resist arrest because she had refused to cooperate with showing any kind of identification. So the state's recommendation on that case was 12 months served, 52 days, credit for time served 16 days. That's from July 1st, 2024 until today. Again, that's also based on the past willful obstruction where she received 12 months in jail. Stay away from Sherwin-Williams at 1792 Washington Road in East Point, a $300 fine, which is statutory. Count 2, the loitering would be time served. The state would ask the defense to stipulate to venue factual basis and identification for the purposes of this non-negotiated plea. We would also like to sound from Ms. Stephanie Bruce in case she is present today.
If Ms. Bruce is present and wishes to address the court, now is your opportunity to do so. Yes, Ms. McLeod.
We stipulate.
Okay.
Your Honor, we are okay with everything in the state's recommendation except the time. My client has served, I believe she's been in jail for the past 20 days. And we would just like the court to make the time that she has to serve end today. We are okay with the other terms of the recommendation, the probation, the fine, and the anger management. And that is why the plea is non-negotiated.
I'm inclined to accept the recommendation for position 40, the battery. Position 41, I will give her time served, 16 days in that case. If she needs to have the fine converted to 30 hours of community service, I'm happy to do that as well. So that would be the sentence of the court if she wishes to plead guilty.
Yes, Your Honor. And she will plead guilty on the other one as well.
Okay. And do you know if she prefer to pay the $300 fine or have 30 hours of community service?
Well, I will ask her right now, Your Honor, because we did not discuss that in particular. So I'll just ask her. Miss Shirley.
Unmute ACDC, please.
Miss Shirley, would you prefer to have community service instead of the $300 fine? Or would you just go ahead and pay the fine?
The community service.
That's what I thought. She would prefer if she gets community service for that, Your Honor.
Okay. Very good. If nothing further, Ms. Shirley, it's my understanding that in case 24 CR 003350C, you wish to plead guilty to battery, and in case 24 CR 004326C, you wish to plead guilty to willful obstruction of a law enforcement officer and loitering. Is that correct?
Yes, I guess, because, yeah.
Okay. Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented.
In here. Fine.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and if I plead these charges, and if I pleading guilty to them, you're giving up your right to a trial by jury?
Yeah.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept your plea, Ms. Shirley. Ms. McLeod, is Ms. Shirley residentially challenged?
No, Your Honor, not based on what she tells me. She gave me a good address.
Okay.
Let me just continue to do that. Yeah,
May I speak with Ms. McLeod and Ms. Falk in a breakout room, please?
Yes, sir.
Yes, sure.
Thank you. I'm back with you, Ms. Shirley. The court accepts your plea on both positions 40 and 41. The sentence for position 40, the battery would be 12 months to serve 60 days, credit for time served 20 days, balance probated, a mental health evaluation, and any treatment that's necessary. Stay away from the higher quest at 1751 Washington Road in East Point. No further contact with Stephanie Bruce. I also want a social worker visit to assist you in any way that you need assisting. For position 41, the willful obstruction, 12 months to serve 16 days, credit for time served 16 days, balance probated. Stay away from the Sherwin-Williams at 1792 Washington Road in East Point, 30 hours of community service. For the loitering, it will be time served, 12 months to serve 16 days, credit for time served 16 days. Ms. Atai, are you there in the courtroom, in courtroom 2?
Yes.
If you'll do me a favor, Ms. Atai, Shirley is Ms. McLeod's client. Would you assist the court in having a social worker visit Ms. Shirley for any housing issues that she may require?
Yes, Your Honor.
All right, I appreciate that. Thank you.
Thank you, Mr. Ty.
All right. Excuse me, anything further on Ms. Shirley this morning?
Nothing further, Your Honor.
Okay, good luck to you, Ms. Shirley.
Okay, we can go to the add-on position number 1, Mr. Jeffrey Harper.
What's your announcement on Mr. Harper?
Your Honor, this was reset to the calendar simply to check on the status of the Superior Court transfer request, I believe. At the same time, I was talking with him to ask if his friends or relatives were going to make his bond, which is at this rate only it's $1,000 surety bond. I've been trying to get hold of several of his folks, and I have not been successful.
Is there a possibility that this could be transferred, Ms. Falk?
It should be transferred, Your Honor. He definitely has the requisite number of previous convictions that it is recidivist. I did reach back out for the second time to the DA's office and presented them with the convictions as well as the transfer order. I'm still waiting to hear back from them. I will say their previous sentence against Mr. Harper was in 2019 for theft by shoplifting, where he got 10 served 1. And that was based on the fact that he was already a recidivist. So this isn't I guess we are not just recommending this to recommend this. There is a basis for the recommendation, especially because in his 2019 conviction, they listed all of his previous theft by shoplifting convictions that made him a recidivist back in 2019. And then he was convicted of that case. So now he has over 4 theft by shoplifting convictions where the required amount for recidivism is only 3. So as I said, I don't see any reason why they should not accept this case, being that they literally have already convicted him of felony recidivist theft by shoplifting 5 years ago.
Given that he has a bond, Mr. McLeod, why don't we reset this until next Tuesday, 7/23, to see if the case is transferred. If it's not transferred by that time, I'll consider a bond modification.
Your Honor, he's not my client.
Thank you, Your Honor.
Right, I'm sorry if I misspoke.
It's all right.
Okay.
See you then.
Who do we have next?
Can we go to position 18, Mr. Gary Grace? That's the job.
Judge will try to see if I can.
And Mr. Grace is your client, Ms. McLeod?
Yes, Your Honor, Mr. Grace is my client.
What are we doing with Mr. Grace this morning?
Harper.
We're going to see if we can have a bond modification, Your Honor.
Good morning, Mr. Grace.
Good morning, sir.
I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you really have your case heard by video?
Yes, sir.
Thank you. What is the, Ms. Tyson, can you give me the history, please?
With 13 arrest cycles beginning in 2006. His last arrest was in Douglas County, December 15th of 2022. That was for a misdemeanor violation of probation. He has an additional violation of probation from 2021 and 2018. He has a felony conviction out of Gwinnett County for possession of a Schedule I controlled substance. Disposition date on that case is, possession of a Schedule I controlled substance and possession and use of drug-related objects. That's from June of 2018. And he has a misdemeanor conviction for disorderly conduct out of Douglas County. That's from December of 2018. He has an FT from 2015. And it looks like he has another felony conviction out of Cobb County for theft by shoplifting. He received first offender treatment on that case June of 2014, and his first offender was revoked July of 2015. He received 5 years probation and a $1,000 fine.
What was that charge?
Felony theft by shoplifting.
I'm sorry, say it again.
Shoplifting, Your Honor.
Theft by shoplifting.
Oh, okay, thank you.
Yes. Nothing to add, Your Honor.
Thank you, Ms. Lewis. The current bond is a 2,000 surety, 1,000 on each charge. Yes, Ms. McConkey.
Just to ask Ms. McLeod, is your client pleading not guilty?
He is pleading not guilty. As you are aware, Ms. McCarthy, the state's offer would allow him to get out today. But he takes the position that this was a situation where he was wrongly arrested and that the allegations were untrue, and he does want to go to trial. However, he doesn't have anyone to help him to pay this bond. So we're asking for signature bond. Based on what we have discussed, it seems to me that he has a very good defense and he wants to get out of jail. He doesn't want to just accept a plea to get out, because he really feels like he's not guilty. So he wants to be able to defend against this case from the outside. And that is why we're asking for signature bond for him. And this is not a situation, it's not like a family violence or anything. This was something different.
Given that I didn't hear any violence in his history, the state would be okay with this being a signature bond through pretrial services at a level 2 or 3.
Okay. Any objection, Ms. McLeod?
No objection to the signature bond, Your Honor. My client can report.
Okay. So we'll convert the good bonds, $1,000 each, to signature bonds through pretrial level 2, and no further contact with Nicola Riley. Stay away from 588 James P. Brawley Drive, and no drugs, alcohol, or weapons while out on bond. If you would
Your
make
Honor, I need to check if that addresses his home, because this is not a situation. She's just someone in the neighborhood. She is not like someone he lives with. Mr. K, is that your home address?
No, that was hers.
Oh, her home. Okay, that's fine then.
Okay.
Yes,
Okay,
just wanted to
so-
make sure.
And I would ask
Okay.
the court, just as a caution, to sound for Ms. Nicola Riley if she does happen to be on this Zoom.
If Ms. Riley is on the call with us this morning and wishes to address the court, now is your opportunity. Doesn't appear so. So he's to stay away from Ms. Riley and stay away from her home address with the other changes. Can you make those modifications, Ms. McLeod, and get them to the litigation manager, and I'll get them signed and entered?
Yes, Your Honor.
All right. Good luck to you, Mr. Grace.
I have a question, Judge.
Okay.
Does this take days to get the signature vote? I was just wondering.
No, as soon as Ms. McLeod gets it to me, I will get it signed, and then she'll get it back to the jail, and then the jail, if you don't have anything else holding you, will process you out.
Okay.
Right,
Okay.
and I'm gonna be preparing it today.
Yes, ma'am. Thank you.
You're welcome.
Good luck to you, sir.
We already did.
What do we have next?
I have to pull them out. We can go to medical or ACDC.
Okay, who do we have at medical?
We have position number 21 and 20 and 21, Mr. Harper.
Okay. This is also Ms. McLeod's client.
Mr. Zion Harper is my client, Your Honor.
Yes, and what are we doing with Mr. Harper this morning?
This is going to be a negotiated plea, Your Honor.
Okay, very good. Good. So, good morning, Mr. Harper. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Mr. Harper, can you hear me?
Yeah. So, yes.
Okay, we're doing this by video. Is that okay with you?
Yeah.
Okay. Can you raise your right hand for me, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay. Ms. McCockey?
Yes, Your Honor. For position 20, the criminal trespass, the state's recommendation is 12 months concurrent with case 23 CR 008199C. Stay away from 778 Magnolia Way Northwest, Unit 101. No further violent contact with Renzia Sansky. The state's recommendation for position 21, the simple battery, family violence, and criminal damage to property, is for count 1, 12 months, served 64 days, credit for time served 32 days, balance probated, no further contact with Jocelyn Gamora, stay away from 3749 Campbellton Road Southwest, FVIP, 40 hours community service, no firearms. For count 2, the state's recommendation is 12 months to run concurrent with count 1. I would ask the court to sound for both victims, Ms. Jocelyn Gamora and Ms. Renzia Sansky.
If Ms. Gamora or Ms. Sankey are on the line and wish to address the court, now is your opportunity. Okay, Ms. McLeod?
Yes, Your Honor, that is our understanding of the terms of the plea. My client tells me that he's currently homeless, and all the contact he has for purposes of probation is just a phone number. So I just wanted that to be put on the record.
Okay. Mr. Harper, are you with me?
Yeah.
Okay. So, Mr. Harper, it's my understanding that in case 24 CR 003368C, you wish to plead guilty to criminal trespass. And in case 23 CR 008199C, you wish to plead guilty to simple battery, family violence, and criminal trespass damage to property. Is that right?
Yeah.
Are you under the influence of any drugs or alcohol this morning?
No, I was asleep.
Okay, so you've been represented by Ms. McLeod. Are you happy with her representation? Is that a yes?
Yeah.
Okay. You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
Yeah.
Was that a no?
What is it?
Did anyone force you or coerce you to plead guilty?
Oh, no.
Okay, I'll accept your pleas, Mr. Harper, as negotiated. Let's see, I'm gonna have them go to a non-reporting status, the probation, once you complete the term. So the sooner you get it done, the sooner you won't have to report to probation. All right, good luck to you, Mr. Harper.
Thank you, Your Honor.
Welcome.
Next, we have position 44, Ms. Rose Turner, position 44, Rose Turner.
Okay. It's Mr. Ty's case.
Hold on. 44. Rose Turner.
Is Mr. Ty with me?
Yes, yes, he comes, Your Honor.
And then, so
Okay.
we can just go ahead and announce for Yana, position, whatever the last one.
Number is called up.
She can. Actually stay there.
Sorry.
Sorry.
And
That's not what we should do in here.
this is Miss Rose Turner, position number 44. It's a non-negotiated plea. Is that correct, Ms. Ty?
Yes, Your Honor.
Good morning, Ms. Turner. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, good morning.
Good morning. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you. Ms. Tyson, may I get the history, please?
Yeah, Your Honor. It seems as though the defendant only has 2 arrest cycles. Last arrest is the case that's on the calendar, and her previous arrest was September 22nd of 2023 by MARTA police for a criminal trespass. No dispositions listed on the GCIC, Your Honor. Nothing to add.
Hi, Your Honor. This case happened back on July 8th of 2024, and the issue isn't her history. The issue is actually what occurred and what is alleged to have occurred during the course of this case. So this happened at Mechanicsville Library at 400 Formwalt Street in Atlanta, Georgia. Officers found the defendant laying on the steps. They asked if she was okay. They asked the librarian, who stated that the defendant had had an altercation with another unknown female, yelling, and the librarian stated that he did not want the defendant on the steps because it was a fire hazard preventing foot traffic from going up or down the stairs. And so at that point, the librarian and the officer approached the defendant, asked her multiple times, told her multiple times she's not allowed to lay on the steps. She rolled her eyes, turned her head, ignored their attempts to get her to move. At that point, Corporal Allen and Officer Ibanez arrived on the scene to remove her from the steps and get her to leave the premises. While they were taking her hand to try to get her off the steps, she opened her mouth, trying to bite Corporal Allen. Corporal Allen stated, "Don't bite me." And then when the Officer Whitmore grabbed her arm, she bit Officer Whitmore. She also bit Officer Ibanez. It looks like, hold on, let me just make sure it was biting instead of kicking. So she bit Officer Whitmore on the right hand, and for Officer Ibanez, let me just have a moment, Your Honor. I just wanted to look and make sure I have this correct. With Officer Ibanez, she bit Officer Ibanez on the right leg. And so, quite frankly, I was a little surprised this did not go up as a felony obstruction. Usually, if you offer violence to an officer or do violence to an officer where biting the officer would constitute that in both situations, this would have been a felony obstruction, but it is not. It is down here with us. And so our recommendation was to merge count 2, the willful obstruction of an officer, with count merge count 1 with count 2. On count 2, 12 months served 30 days, credit for time served 9 days, balance probated, 8-week anger management, BHET. Count 3, 12 months concurrent with count 1, count 4, 12 months concurrent with count 1, as well as a stay away from the Fulton County Library at 400 Formwalt Drive in Atlanta. Again, and the recommendation for jail time was based on the fact that the defendant bit not one, but 2 different officers, one on the hand, one on the leg. That's all for the state. We would like to ask the defense to stipulate to venue, factual basis, and identification for the purposes of this non-negotiated plea.
It's a tie.
Your Honor, my client, she stated she has no problem with the offer as far as the time served or the 9 days requiring 12 days left. But she does not have the ability to report to probation or complete an anger awareness or, and she denies that she needs a BHET. She doesn't have any MH issues. She is a Georgia resident. She's 43 years old with 0 convictions. And this was only her 2nd arrest, Your Honor. She does have an address in Atlanta, but I believe that she has been residentially challenged for many years. She does state that she does not have a phone. She doesn't have a mode of transportation. And the only connection that she kind of had with the world was by being at the library, which she now understands that she has to stay away from the library. So I would just like to ask for 30 days credit for time served, 9 days, but she can't report to probation or complete the anger awareness. So I would just like to ask for the time served.
Okay,
And that will be with her serving 12 more days.
and what about the BHET?
Your Honor, I don't exactly know how BHET is, I mean, she has 12 more days. The BHET can be done, I think, within that time.
And actually, based on this calculation, she would only have 6 more days. She's already served 9 toward 30.
Okay. All right, I don't want to set her up for failure, so I will require the social worker visit for the BHET within the next while she's still in custody. I also would like the social worker to assist her with any housing for when she is released.
Okay.
Okay, Mr. Ty.
Okay,
Anything further before I take the plea?
nothing further.
Ms. Turner, it's my understanding that in case 24 CR 004477D, you wish to plead guilty to 2 counts of simple battery and criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Satisfied.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept your plea, Ms. Turner, for the first simple battery. It'll be 12 months to serve, 30 days, credit for time served, 90 days, balance suspended, a BHET, social worker visit to assist with any housing issues. For the second simple battery, it will be 12 months to serve, 30 days, credit for time served, 9 days, balance suspended. And for the criminal trespass, 12 months to serve, 30 days, credit for time served, 9 days, balance suspended, and you to stay away from the Fulton County Library located at 400 Formwalt in Atlanta. All right, good luck to you, Ms. Turner.
You talking about both of them, right?
Both
These both incidents happened at the library for some reason, so both of
okay.
them.
So you can't, yes, but you can't go back to that library,
So I
okay?
can't, okay,
All right, so don't go back there.
it's fine.
Okay, good luck to you, Ms. Turner.
Okay, you too, thank you.
Judge, I'm sorry, this is Katrina. Can you repeat that sentence again? On count 2, you say it's 12 months to serve 30 days credit for time served, 9 days. The balance is probated to do a BHET or a social
balance-
worker?
No, the balance is suspended and she's to have the BHET and a social worker visit while she is in custody.
Okay, so there's no angry management.
No.
Okay, okay, so pretty much it's a balance suspended, but extra time. Okay,
Yes.
okay,
Okay.
I got
All
it.
right.
Thank you.
We
Who do
got
we have?
position number 3 on the probation calendar.
So Mr. Linwood Mack is this Mr. Mack?
Sir. Yes, sir.
Yes, good morning, Mr. Mack. Let's see, I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Okay, and it looks like Mr. Mack is positions 2 and 3 on the probation calendar. Yes, Officer Allen.
Your Honor, the defendant was charged with the offense of battery. He was required to complete anger management classes, as well as report to probation and have no contact with the victim in the case. As of today, the defendant has failed to provide our office with completion of the anger management course. It's 240 days remaining on his case. He has been in custody since July the 8th, 2024. Your Honor, we ask that the defendant be allowed to continue on probation to complete the course.
Ready?
Your Honor, when I went to speak to Mr. Mack yesterday, I did see in the jail that there was an incident between himself and the officers. And so I'm not sure if Mr. Mack will not speak to me or if the officers wouldn't allow him to speak to me because of the incident. And so if he would like me to speak with him, I'm more than happy to, but I actually have not spoken with him. They had an altercation and I couldn't speak to him.
Okay, Mr. Mack, would you like to speak with Ms. Vigiletti this morning so she can help you with your case here?
Yes, sir.
Okay,
Okay.
I'm gonna give courtroom 2 a call and we can talk and we'll come back in just a minute.
Okay,
Ms. Bishop.
we'll be back to you, Mr. Mack. Thank you.
Yes, sir.
Position number 47, Wise.
Richard.
And this is also Mr. Ty's case. While I'm waiting for Mr. Ty, good morning, Mr. Wise. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can place your hand down, Mr. Wise.
Okay, thank you.
So whenever you're ready, Mr. Ty.
I'm sorry, Your Honor.
No, finish your business and just let me know when you're ready.
Wait, this is position 45?
47.
7.
Okay.
It's my understanding it's a negotiated plea.
Oh, yes, Your Honor.
Okay. I've already sworn him in. Yes, Ms. Fall.
Yes, Your Honor, the state's recommendation is time served, 34 days, credit for time served, 17 days. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
We stipulate.
Okay, anything further, Mr. Ty?
Nothing further.
Okay, Mr. Wise, it's my understanding that in case 24 CR 004251A, you wish to plead guilty to willful obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Wise. Good luck to you.
All right.
We have next.
Position 12, Cox.
Ms.
Vigilante,
Vigilante is on the phone currently with her client.
Okay.
And Your Honor, for ACDC, the last two females I have belongs to Ms. Vigilante also.
Okay.
And when we finish with them, I have to go get position 46, Mr. Williams.
Okay. So as soon as Ms. Vigilante gets off the phone, we will proceed.
Would you like? Yeah. And Your Honor, position number 22, Mr. Norris Henry wanted to go pro se. He was originally, we set it to the next calendar. But he wants to do pro se today.
Let me speak to Mr. McLean about that.
Sit.
Your Honor.
I'm being told, Mr. McLean, that position number 22, Mr. Norris Henry, who we have previously reset to July 23rd, wishes to proceed pro se today.
He does, Your Honor. I explained to the court within his hearing earlier this morning the reason for the reset. I think he's unhappy.
Okay. And is this Mr. Henry that's in medical?
No, he's right behind us on the second
Okay.
bench.
I guess have him come up.
I asked if he wanted to talk about it. He does not to me anyway, and not to any other public defender either.
Okay. Good morning, Mr. Henry. Let's see. You've been charged in case 24 CR 004033Y with battery, family violence, cruelty to children, and a third degree in criminal trespass. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We've offered you the help of the public defender this morning. It's my understanding that you wish to proceed without their assistance and pro se. Is that correct?
Yes, sir.
Okay. What would you like to do with these charges today?
I would like for them to be dismissed, sir.
Okay, they're not being dismissed. I will give Ms. McConkey, is this your case?
Sir?
Yes,
Hold
this
on.
is my case.
Okay, can you tell the court what the recommendation and Mr. Henry is, what the recommendation for a guilty plea is?
Yes, and I also want to point out he does have an add-on 23 CR 008017Y.
Okay, and that's for battery, family violence as well?
Yes, with the same victim.
Okay, what's the recommendation?
The recommendation for position 2224 CR 004033Y. For count 1, it is 12 months consecutive to 23 CR 008071Y. Balance probated, no further contact with Aaliyah Holder, stay away from 496 Lindsay Street Northwest, an ADET, an FVIP, 40 hours community service, no firearms, third-party contact with the minor child. For count 2, it is 12 months concurrent with count 1. For count 3, it is 12 months concurrent with count 1. For the add-on, the state's recommendation for the battery family violence is 12 months jail, credit for time served 37 days. For the cruelty to children, it is 12 months jail concurrent with count 1. And he does have an open case involving the same victim in Clayton County, which is 2021 CR 1508.
So, Mr. Henry, the state is recommending 12 months in custody for you with credit for 37 days that you've served. So that is their recommendation. If you accept that recommendation, you'll be in jail for the next 12 months.
No, sir, I don't accept that recommendation.
Okay. As such, Mr. Henry, your case will be returned to the division judge and you'll get notification of your next hearing date, okay?
Okay.
All right. Good luck to you, Mr. Henry.
Judge, I would like to negotiate a lower bond in fairness to me. So if you just hit me up for a second. I've been through a lot as a child, but I am not even gonna get into all that. We're talking about these 2 cases right here. I really need to be in my son's life, and I've been an active father since he's been here, and I would do nothing to hurt my child or his mother. We have had our issues, but all I can say is for the last 4 or 5 years, it just hasn't been an easy ride just getting along with his mother. But I swear I tried my best. I had these last 30 days to reevaluate my whole life. And I know what I need to do going forward. I understand that the relationship is over and I just need to be focused on my son. But I can't do it in jail. I'm losing my mind, trying to stay positive, trying to keep God in my life, but I can't do it where I'm at. I really need help. I dealt with a lot of traumatic experience as a child that I ain't really resolved. I just need help. I don't need to be in jail though. And I can't beat up for my son if I'm in jail. And I don't deserve it. She know
Okay, hold on, Mr.
I
Henry.
don't deserve it. I
Hold
don't.
on, hold on, Mr. Henry. I'm hearing you. So, Ms. McConkey, what is his current bond?
His current bond for position 22 is a $4,000 cash bond, $2,500 on the battery family violence, $1,000 on the cruelty to children, $500 on the criminal trespass, no further contact with the victims, a stay away, no drugs, weapons, or alcohol, and an FVIP. That was from George Mincy. But I would like to point out that for the add-on case that happened in 2023, he had a $5,000 pretrial release bond, no further violent contact with the victim, and 5 anger awareness classes. And that was signed by you, Judge Morrow, and he proceeded to violate that and have this incident with the victim. And this is his 3rd time because he does have that 2021 case out of Clayton County. So this is his 3rd violent incident with this same victim. And so we are not going to agree to any bond reduction. We think that this bond is very appropriate given his history and his multiple violent incidents with this victim and their child.
Okay, so Mr. Henry, you've apparently seen me before, and I gave you some conditions. I gave you actually a pretrial bond, is my understanding. I let you out at one point in time. And you allegedly violated that bond by the other by having contact. So you've already disappointed me on one occasion, Mr. Henry, when I gave you an opportunity to get out. Okay.
I understand this, Mark. Can I just make one more? If you look at my criminal history, I have no other arrest outside of just the struggles I've been dealing with my child's mother. I don't commit crimes. I'm really not a violent person at all. It's just been in this relationship, it's just really been a struggle. Like, I'm not a bad person. Like, I really take care of my son, I even take care of her. Like,
Okay,
I just
nobody,
give you another
I'm
chance.
not saying you're a bad person, Mr. Henry. Well, all I'm saying is that I gave you an opportunity before, okay?
It's a lot
And
of application.
listen to me. I gave you an opportunity. You promised me something, when I gave you that opportunity, when I let you out last time. And you've disappointed me because you returned and, you know, you allegedly committed another type of incident. So I can't give you that opportunity again, Mr. Henry. So what I'm gonna do is I'm going to return your case to the division judge, and you can make any request for bond modifications at your next hearing date, okay? All right, so good luck to you, Mr. Henry. We're done, courtroom 2, we're done with Mr. Henry this morning. Okay, good luck to you, sir.
Is vigilante ready now?
Yes.
So Judge, take them off for next Tuesday?
Yes, further notice.
Ms. Vigilante should be back on in a second. No, I don't know. I was waiting. You got a key? Yeah, wait, I got it. Your Honor, we can go to medical for Ms. Vigilante.
Okay.
Position 12, Cox.
Okay.
And Your Honor, I did speak with the state this morning about Mr. Cox, and this will be a negotiated plea.
Okay, very good. Good morning, Mr. Cox. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. How are you today?
I'm well. I hope you are as well, Mr. Cox. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. Yes, Ms. McConkey.
Yes, Your Honor. The state's recommendation is 12 months, serve 32 days, credit for time served 16 days, balance probated, no further contact with Charles Mulej. Stay away from 1492 Piedmont Avenue Northeast, an anti-theft course, 40 hours community service. And we are fine with this going into non-reporting status once he's completed those terms. And finally, I would just ask that the court sound for the victim, Mr. Charles Mulej, and that the defense stipulate to venue, factual basis, and identification for purposes of the plea.
Mr. Mulej is on the line and wishes to address the court. Now is your opportunity to do so. Okay, yes, Ms. Vigilante.
We do stipulate for the purposes of the plea, and I would just like to say it one more time in layman's terms, since I have not talked to Mr. Cox this morning. Mr. Cox, the state did agree to what you requested, which is that once you complete the anti-theft course and the community service, you don't have to report to probation anymore, okay? Okay, good. I think we're ready to proceed, Your Honor.
Okay.
Let you know.
Mr. Cox, it's my understanding that in case 24 CR 004321A, you wish to plead guilty to theft by taking. Is that correct?
Sure.
Is that a yes?
Yes, sir.
Okay. Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
100%.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Cox. As soon as you get through the anti-theft class and the 40 hours of community service, it'll go to a non-reporting status, so you won't have to report or pay those fees, okay? All right, good luck. Can you unmute medical so I can hear what he's saying?
I'm sorry. You said it will be completely, I won't do probation at all, correct? Once I do this.
It'll go to a non-reporting status, so you won't have to report and you won't have to pay the fees.
Okay.
Okay. All right. Good luck to you, Mr. Cox.
Am I out on a signature bond after this today, or?
No, this was a guilty plea today, so you're getting credit for time served. So if you don't have anything else holding you, then once the jail processes you out, you will be released.
Okay, thank you. Have a good day.
Welcome. You too.
We can go back to position 2 and 3 on the probation calendar, Mr. Linwood Mack.
Okay, and where are we with Mr. Mack's case? Ms. Vigilante?
Yes, Judge. So I just spoke with Mr. Mack, and you know, he told me about when he was initially released from custody, he did report to probation at least one time, where his officer told him he already owed fees and was telling him about how this anger management costs money. And Mr. Mack is on disability income. He does receive SSI, and he became overwhelmed and made the mistake that we see frequently of not going back. We discussed, you know, that kind of being the worst option. And I've also given him my phone number so that if he's running into issues in the future, he could call me. We can work something out together. He does want to make this right, Your Honor. I did send him an affordable anger management option as well. If Your Honor would consider, because he does have disability income, and as you know, that is capped very low, waiving his probation fees, I think that would be very helpful to Mr. Mack.
Okay. So how much anger management does he have?
They've requested 6 classes.
6? And that's all. So just, and Officer Allen, so 6 anger management classes, and what else? Anything
And I'm
else?
sorry. Yes, it was a behavioral health evaluation, so probably a mental health evaluation, which I'm assuming he should be able to get that with Grady.
Yes, and we discussed that as well, and he knows where to go to get that done.
Okay.
Okay. I want him to get through this as quickly as possible so we can get this behind him. So to encourage you to do that, Mr. Mack, I'm going to waive the next 3 months of probation fees for you. So hopefully you can get the classes and the evaluation done in that amount of time, so you can get this put behind you and you can move on, okay?
Yes, yes, sir. Thank you.
So I will reinstate you. I'll waive 3 months of probation fees to help you get everything done, and hopefully I won't see you back here again, okay?
Yes, sir. Thank you.
All right, good luck to you, Mr. Who do we have next?
We can go to position 6. And 7, Mr. Miles. Sebastian Miles, 6 and 7.
Okay, and what are we doing with Mr. Ashley? Is that right?
Your Honor, this is on the probation calendar.
Oh, I'm sorry. Okay, good morning, Mr. Miles. I'm Judge Eric Morrow. This is the probation revocation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir, it's fine.
Thank you.
Good morning.
Yes, good morning, sir. Yes, Officer Allen.
Your Honor, the defendant was charged with 2 counts of cruelty to animals, where he was required to pay probation supervision fees, complete a BART course, and no animals while on probation. Your Honor, the defendant has failed to provide our office of the BART course completion certificate. The defendant has failed to report to our office. It's 150 days on remaining on his case. Your Honor, we ask that he be allowed to continue on probation. But Your Honor, with the BART course, just to kind of explain, the BART course has to be set up by the state, not probation. So I ask that if he's allowed to continue on probation, that he be allowed to complete animal sport instead. And that is actually a cheaper program, and he will be able to actually enroll in that program without the state or the probation.
Okay. Any objection to any of that, Ms. Vigilante?
No, Your Honor, and that actually clears up a huge question I had for Officer Allen, because Mr. Miles does tell me he spoke to Miss Harris, who I know is no longer with your office, 4 times, and she was telling him he couldn't start the class yet because she didn't have things in place, and I wasn't quite sure what that meant. So that tracks with what
the state has to set up the BART. It's not something that we can set up.
Understood. Well, in that case, I don't think, Your Honor, will have Mr. Miles will have any issue getting this done. He knows where to go to speak to probation, and if they could just give him, the info about how to do this alternative class, we should be able to get this taken care of.
Okay, so Mr. Miles, I'll reinstate you on probation. I would encourage you to go ahead and get everything done as quickly as possible so you can get this behind you, okay?
Yes,
All right, good luck to you, Mr. Miles.
thank you.
They're gonna give it to you.
Who do we have next?
Probation 9 and 10. Strozier.
Yes, good morning, Mr. Strozier. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Yes, Officer Allen.
Your Honor, the defendant was charged with the offense of battery, where he was required to complete the domestic violence program and have no contact with the victim. As of today, the defendant has failed to provide our office with completion of the domestic violence course. Your Honor, he has 235 days remaining on his case. The program is a 6-month program, so at this time, we'll defer to the court on recommendations.
Ms. Vigilante?
Yes, Judge. I spoke to Mr. Strozier. He did tell me that upon leaving the jail, he asked for a number to call for probation. And I do not know this for a fact, but I do think it's possible he was given felony probation's number, just based on what he's telling me, that he called several times and that the person he spoke to told him he was not in the system yet. I know when I've tried to call the JCS Central number, you don't typically get a live person, so that does not sound like misdemeanor probation to me. But much more importantly, he was arrested on July 28th and has been in custody ever since. So he has spent a full year in custody. He really didn't have a chance to make this right or figure out what was going on, why he was being told he wasn't in the system. I did send Your Honor and yourself as well, Officer Allen, the best proof that I could get on this notice of him being in custody. He tells me he was arrested in Clayton County on July 28th and that he's been in custody ever since. I did send you the docket for his initial arrest, which is exactly on the date that he said it was, July 28th. And then I've sent you, that case ended up being transferred. And so I sent you that bind over, and that his final disposition was July 1st. He then came to us, I believe, on July 3rd. And so that all tracks with what he told me. He did take a plea to first offender status. So I don't know much about what that is going to look like in terms of his actual requirements. But given that he will still be under supervision and he has been in custody for the past year, if Your Honor would be willing to consider time served, he will still have significant rehabilitative requirements under his felony conviction, or in the alternative, he does have enough time to complete the FVIP class if you would be willing to consider continuing on probation.
Okay, I want him to do something on this case, and as he promised to do, so I will continue him on probation. He has enough time to get the DVIP class done. I want him to enroll in it within the next 7 days, or 7 days of when he gets out of custody, so he can go ahead and start getting that completed. Okay, I'm going to give you the opportunity, Mr. Strozier, given your circumstances, but I want you to go ahead and start getting the class done, and make sure that you report to probation when you're supposed to report. Okay.
Okay. Last year, I didn't get no address or no phone number. Just want to make sure.
We're gonna make sure you get it this time, okay? All right, so Ms. Vigiletti, make sure that he gets where he needs to go, so that he doesn't have this issue as we go forward.
Yes, Your Honor.
Do he need to report to 132, Mitchell?
Yes, officer.
I'll write it down for him.
Thank you so much.
All right, very good. Good luck to you, Mr. Strozier. Who do we have next?
Position 48, Ms. Wright.
That's Mr. Ty's case.
Okay, is Mr. Ty busy at this?
No, Your Honor.
Okay. And this is a non-negotiated plea?
Yes,
Ms. Wright? Yes, good morning, Ms. Wright. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
You can place your hand down. Thank you. May I get her history, please, Ms. Tyson?
Yes, Your Honor. We have 16 arrest cycles beginning in 2010. We have a misdemeanor conviction for simple battery from 2012 out of Fulton County. In the last 10 years, we have a felony conviction out of Columbia County for 2 counts of forgery in the 3rd degree and 1 count of forgery in the 4th degree. That's from June of 2020. We have a violation of probation from, let's see, it's like 2020 and 2023, and also 2024. misdemeanor conviction out of Columbia County for battery family violence first offense from May of 2023. And it appears as a another possible pending case out of Atlanta. The arrest date was April 19th of 2023, and that was for battery family violence as well. And our last arrest was August 20th of 2023, Georgia State University Police, simple battery, possession and use of drug-related objects, and simple battery. No dispositions listed on the GCIC for that case, Your Honor. And it looks like she does have a hold for Columbia County. And there is an open PI case. 1 second. Case number is 24 PI 004779. And the charge is financial transaction card theft. Nothing to add, Your Honor.
So all the battery family violence, simple batteries, those are all of them, they're all open. Is that right?
The only one that I have that does not have a position on it is arrest from April 19th, 2023, battery family violence out of Atlanta.
And that is closed. So I do have that case number for Your Honor.
And Your Honor, I'm sorry. I did speak with her boyfriend who was there at the time, and actually, this is going to be a bond argument.
Okay, so it's not going to be a plea.
No, Your Honor, and yeah, no.
All right, so I still need to know, are there any convictions for battery family violence? Can you tell me that, Ms. Falk?
There are 2 convictions for family violence battery, Your Honor. The first one is going to be 17 CR 012591A. That is for family violence battery. The defendant received 12 months with 34 days to serve, credit for 17 days. That conviction was on April 12th of 2017. The second conviction for family violence battery was under 23 CR 002453H. That was ordered by Judge Mincy. That sentence was for 12 months with 60 days to serve. That was May 4th of 2023. She also received a no further contact and family violence intervention program on that case.
Okay. And what is her current bond?
Her current bond, Your Honor, is on this case is $2,000 surety bond. On her financial transaction card case in felony court under 24 PI 004779 is a $2,000 surety bond. She has no bond on her probation violation, which is currently on the jail screen, and no bond on her foreign hold out of Columbia County.
Okay.
And the misdemeanor probation violation looks to have been filed August 17th of 2023 for that 23 CR family violence battery. Failed to complete as directed, failed to appear, failed to pay supervision fees.
And I take it that the state wishes for the bond to remain the same.
That is correct, Your Honor. She, under the Ayala factors, she has a history of violence. She has not been compliant with probation, which we believe means she will not be compliant with a court order since the court ordered her on probation with those terms and conditions. And we also believe that based on her history, she's just not a good candidate for a signature bond through pretrial or through any other method.
Okay. And apparently I agreed with you because I gave her that bond on the SEA calendar. Okay, Mr. Ty?
Yes, Your Honor. My client, she does deny the allegations as stated in the warrant. She's charged with battery, affray, and possession and use of drug-related objects. She states that on June 30th, she was leaving Grady with her boyfriend. They were there to visit her mother and his father, who were in Grady. Her mother was in the ICU. When I spoke with her, she told me what happened. She stated that this person chest iron, Finkley, got in her face, put his hand in her face, and she used, she was defending herself, Your Honor, and her boyfriend told me further that he grabbed a piece of, a pallet and a piece of wood with nails in it to attack, my client. And I could not get in touch with the complaining witness. I do believe that he is residentially challenged and lives out in the streets. And I mean, Your Honor, in this case, I mean, it's stating that the battery is the use of pepper spray, which she states, and her boyfriend who was there states that she used in self-defense. So I would ask in this case, because of, you know, the nature of the incident, I would ask for a signature bond for pretrial services. She didn't ask for this to happen. She didn't ask to be leaving the hospital and be attacked by somebody and have to use pepper spray, but that's what it's for.
And Your Honor, just to inquire, because I'm looking at the warrants now, what is the boyfriend's name?
His name is Antoine Dixon, and I believe he is on the line on the Zoom call.
Anything further from anyone?
No, Your Honor, other than the fact that Officer Dodson, who arrived, actually saw all she and the other individuals fighting, throwing punches at each other, and then saw the defendant disengage from the altercation, pull the pepper spray, and then spray Mr. Finkley in the face. So the officer did observe a portion of this altercation and recorded that all three were involved in the altercation. And then at that point, the defendant then pulled her pepper spray and sprayed Mr. Finkley directly in the face. So Your Honor did see fit to grant a $2,000 surety bond, I believe, because of all of the factors that I had laid out, and we ask that that bond remain as set.
Okay. Given that I set this bond, I don't see that anything has changed since I set it. I'm sure that I heard from everyone at the time, so I'm going to leave the bond case as
Mr.
it.
Dixon didn't make a statement.
Okay. Well, I'm happy to hear from Mr. No one has asked me to hear from Mr. Dixon, so if Mr. Dixon would like to address the court, I'm happy to hear from him. If he chooses to, I'll need for him to raise his right hand. Mr. Dixon, can you hear me?
Yes, sir.
Okay, would you like to make a statement?
Yeah, I'm she was like, it was set the fence.
Hold on a second, Mr. Dixon. Raise your right hand for me, sir. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. What would you like to tell the court?
Okay. The hospital, but seeing my dad and my mom was on the try to going home. Got off to try. The dude kept saying something to her. The dude, like, how you say? I don't want to be. He gay. He was gay. I'm understanding. He a dude though, still a dude. And she maced him. That's in self-defense. I can see it was me and him going at it. I can take the charge. We both dudes. Like she's a female. She had to use pepper to mace him. He still got dude strength. Even though he considers himself as a female, but he still have dude strength. You feel me? Then when I try to make a statement, to police officer, they act like they didn't want to hear me.
Okay.
Cause one of the officers said, "Why is you talking to me? I ain't got nothing to do with that, but he was just down there talking to my girl about the incident."
Okay. Anything else, Mr. Dixon?
Why she can't get dropped or get a censor bun on it. And she need to get home to her kid. I'm like, I'm not used to being a stay-at-home dad, but I gotta be a stay-at-home dad.
In addition to this, she also has another hold, is my understanding. She also has another violation that she's going to have to deal with. So I appreciate what you're telling me, Mr. Dixon, but it's more than likely it's not just this incident. She'll have a chance to come back and make a case for it, but at this point in time, I'm going to leave the bond where I set it initially. Okay. Good luck to you all. Who do we have next?
Position number 25, Corey Jackson.
Let's see. Also a non-negotiated plea.
Yes, Your Honor.
Mr. Jackson, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you place your hand down. Thank you. Ms. Tyson, please, the history.
So we have 10 arrest cycles beginning in 2008. There's one FTA from 2012, and within the last 10 years, it appears that there's no convictions, felony or misdemeanor. Let's see, 1 second. His last arrest was February 2nd of 2024. And that was for battery, family violence, criminal trespass, and cruelty to children in the third. No disposition listed on the GCIC for that case, Your Honor. Let's see, 1 second. Nothing to add, Your Honor.
Well,
Yes, Your Honor. His last arrest was actually the most recent case that's on the calendar, which is the 24 CR 004146E case. That was the June 24th, 2024 incident. All of these incidents involve Yanira Ghani. And the first incident that I will go through is going to be the first case on the calendar, which is the June 26th case, and then I will talk about the add-on case. So this happened June 24th of 2024. Officers went to 115 Rumson Road in reference to a dispute call. They spoke with Ms. Ghani, who stated she was in bed with the defendant, who said something. They then got in, she didn't hear what he said, asked him to repeat it, and then they got into an argument. The defendant then pushed her off the bed. She got up, asked him why he pushed her. He pushed her again. She did state this isn't the first time the defendant has gotten physical with her. There was a history of domestic incidents. The same officer who was at that location had actually arrested the officer for simple assault previously. At the time of the defendant's arrest, he had an iPad, an iPhone, a wallet, car keys, as well as a STR-9C handgun with 11 9mm rounds. The previous incident, Your Honor, for which a bond was given, one of the conditions of which was to stay away from Ms. Ghani, that incident happened back in January of 2024. In that particular incident, which occurred, and let me just make sure I have my date correct, which occurred January 15th of 2024, for which the defendant was then arrested in February of 2024. That incident involved the defendant at the same address, 115 Rumson Road Northeast, number 19. The officer went out to that location and spoke with Miss Ghani in reference to a domestic dispute. She stated she was assaulted by the defendant inside of her apartment. She asked him to repeatedly leave the apartment, but he refused. She went into the bathroom to take a phone call. The defendant came into the room, started yelling at her very loudly. She could see their 3-year-old daughter, SG, sitting on the edge of the bed less than 10 feet away while this was happening. The defendant then snatched her Samsung phone, threw it against the bathroom wall, making a hole, and that her head also struck the bathroom tile during this incident, during the physical altercation, which caused her to have pain in the back of her head. Officers were able to observe a visible red bruise on her forehead while she was speaking to the officer, and they asked the Miss Ghani how her daughter was affected by what she saw, and she advised that her daughter was afraid to get off the bed and had a difficult time sleeping following this incident. We did have an opportunity to speak with Miss Ghani on both of these cases. She does agree with the plea offer. She stated she will not be on Zoom, but we will ask to sound for her. The recommendation in total is 24 months, serve 180 days, credit for time served 4 days from February 2nd to February 5th of 2024. And then from it would be a total of 27 days. Then from June 24th, 2024 to today. We were also asking for balanced probation, family violence intervention program, 40 hours of community service, no firearms, stay away from, no further contact with Yanira Ghani, stay away from 115 Rumson Road in Atlanta. And I believe I did already state no firearms. This would be based on a global recommendation from the simple battery family violence and then the subsequent battery family violence, which also had charges of cruelty to children in the 3rd degree, as well as criminal trespass and damage to property. We would like to sound at this time for Ms. Yanira Ghani and would ask the defense to stipulate to venue factual basis and identification based upon this non-negotiated plea.
So just so I'm clear, for the case ending in 603E, how much time credit for time served does he receive?
So, Your Honor, and I'm going to kind of, the way we can do this is it looks like we asked for 12 months served 46 days, credit for time served 23 days on the simple battery family violence. On the battery, it looks like we asked for 12 months probation serve 180 days, credit for time served 4 days. What I will do is reduce the amount of, I will reduce the amount of time to serve by an additional 23 days to account for the discrepancy between the first and second offense. Balanced probated family violence intervention program, 40 hours of community service, no firearms, no further violent contact, no further contact, and a stay away. And then on count 2, it's 12 months concurrent with count 1, and count 3 is 12 months consecutive with count 1. So if I could just do some brief math, and I will be able to reduce that amount by the corresponding amount of time he served on the simple battery.
My calculation, if it's reducing it by 23 days, or would the recommendation be 12 months to serve 157 days, credit for time served 4 days?
Yes, Your Honor. Thank you.
Okay, yes.
Yes,
Let me
sir.
see. Let me just sound for Ms. Ghani. If Ms. Ghani is present and wishes to address the court, now is your opportunity. Okay. Yes, go ahead, Mr. Todd.
Your Honor, I think she was on earlier. She told me that she would be on today. He was reset a week. So the last time that we were here, well, she didn't make a statement, but she told me that she does not want to press charges for the most recent case, which is the charge that he's being held on. You did state, and he needed time to think about it, that you would consider 90 days credit for time served 23 days with the FVIP and 12 months of probation as a global offer for both cases, Your Honor. So that would leave him, if that offer from last week is still available, that would leave him with 22 more days to serve here, or 44 or 22. And instead of so I would ask for that offer from last week, which he had time to think about, but instead of sitting here for 22 more days, and I was hoping that the complaining witness would be on, she did tell me that she would, and she was on earlier, Your Honor. That instead of the 22 days, the balance to be suspended and add to that offer from last week, 40 hours of community service. And so then he's not here for the 22 days, but he's doing 40 hours of community service, and he can start that 24-week FVIP while engaging in community service rather than being here for more than 3 more weeks.
Okay, I'm sorry, I'm just trying to pull my notes from last week.
You ready?
I am looking at my notes from last week, Your Honor. It says non-negotiated. Judge agreed to 12 months, serve 90 days with conditions.
Okay. So now instead of credit for time served 4 days, he would have been in for an additional 7 days, right? 7. So that would give him credit for time served 11 days.
I believe it would be 23 days.
That is correct, Your Honor. It is 23 days.
Okay. Okay, so I will honor what I said last week. I do remember now that I gave him the option of coming back and considering the offer.
Well, and Your Honor, I'm not exactly clear. It doesn't sound like they're agreeing to what Your Honor.
Well, I'm asking, yes, for that, but that would leave him with 22 more days. So I would just ask to add to what Your Honor stated last week, 40 hours of community service, and also doing the FVIP, but to suspend the balance of the 22 days for the addition of community service.
Okay, no, I'm gonna go with I'm gonna give him the option of what I offered him last week. Whatever it was that I offered him last week, then I extended him the opportunity to think about that. So I guess at this point, what I'm saying is that it would be for the 603E case, 12 months to serve, 90 days, credit for time served, 23 days, balance probated, an FVIP, 40 hours of community service, no firearms, no further contact, stay away. So,
Your Honor, last week you stated FVIP, 12 months of probation, 90 days with credit for time served, which is now 23 days, and the FVIP. There was no community service.
I disagree. What I have is the judge agreed to 12 months, serve 90 days with all remaining conditions. That's what my notes have. I will express I think I'm a little bit thrown off by the fact that it sounds like it's a non-negotiated plea of the judge's sentence.
Well, it's a non-negotiated plea referring back to that sentence. So it's non-negotiated because that's not what you asked for.
Correct, but I think the judge had given from previously what he would proceed on, and it sounds like it's still trying to be negotiated.
Yes.
What I've said is that I have it underlined with regards to the conditions. I have it underlined FVIP, underlined 40 hours of community service, underlined no firearms. So I was going to give him a break on the jail time, but he was going to have to do all the other conditions that were recommended by the state. So I'm willing to make good on that today if that's what he wants, if that's what he chooses to accept.
So to be 22 more days to serve.
Whatever that calculates up to be.
And we spoke about that.
That's correct. It'll be 22 more days.
Okay, so what are we gonna do?
Yes, sir. That's fine. 22 more days and serve and do the probation and community service.
Okay. All right.
Can I have like some type of paperwork? I know I got to do 22 more days, and I got probation, and I have I'm trying to see what else the stipulation is. If I can have like paperwork to see what's
Yes, sir. Mr. Ty will get with you to make sure that you have everything that you need before you leave the jail. Okay.
Thank you, sir.
Anything further before I take the plea?
Nothing further.
Okay. Mr. Jackson, it's my understanding that in case 24 CR 004146E, you wish to plead guilty to simple battery family violence. And in case 24 CR 000603E, you wish to plead guilty to battery family violence, cruelty to children, and criminal trespass, damage to property. Is that correct? Have to answer yes or no for me.
Yes.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
Did you hear my question?
Yes, sir. No.
Okay. You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept your guilty plea, Mr. Jackson. Let's see, for the simple battery family violence, the court's sentence will be 12 months to serve 46 days, credit for time served 23 days, balance probated, no further contact with Ms. Ghani, stay away from the 115 Rudson Road, Atlanta address, and no firearms. For the battery family violence, the court sentence will be 12 months to serve 90 days, credit for time served 23 days, balance probated, a family violence intervention program, 40 hours of community service, no firearms, no further contact with Ms. Ghani, and stay away from the 115 Rudson Road address. And for the cruelty, 12 months concurrent with count 1. For the criminal trespass and damage to property, 12 months consecutive with count 1. No further contact with Yanni Ghani, and stay away from the Rumson Road address. Okay.
Question. So it's so I serve 22 more days. Then when I get out, I start doing the probation
and completing the terms. Yes, sir.
Okay. Thank you, sir.
Okay. All right, Mr. Jackson. Good luck to you, sir.
Thank you.
Your Honor, next we have under probation revocation calendar, Ms. Manuel. And then when you finish with medical, I have Mr. Position 48, Mr. Williams.
It's quorum too after medical, after.
Okay. That's fine. Okay, thank you.
All right, good morning, Ms. Manuel. Let's see. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Yes, Officer Allen.
Your Honor, the defendant was sentenced to probation for the charge of simple battery. She was required to report to probation, have no violent contact with Jean Manuel, as well as complete domestic violence counseling. Your Honor, she has failed to provide our office with the completion of the domestic violence counseling. She's been in custody since July 8th, 2024. Is 91 days remaining on her case. Your Honor, at this time, I will have to defer to the court because I received some information and Ms. Vigiletta will be able to speak more on it pertaining to her medical condition on why she cannot satisfy the terms of the remaining sentence.
Okay, Ms. Vigiletta.
Yes, Judge, I understand this is typically a situation where we might revoke the balance, but Ms. Manuel is 6 months pregnant. She does have a fairly high-risk pregnancy. She did miscarry last year. And since coming into the jail, she has had some issues with her pregnancy. She has been cleared by a doctor, but she has been having difficulty keeping the jail food down, and she is concerned that she continues to lose weight. Regarding, not satisfying the terms of the plea, I did speak with her at length yesterday. I also spoke with her mother, who is here on the line, Tanya Manuel, if you'd like to speak with her. Ms. Manuel's mother told me that they did, shortly after she took this plea, take her to Anchored, where she did some inpatient days because she had been having some difficulties with MH issues. Miss Manuel told me she did believe it was postpartum because she did have a 2-year-old at the time, but they realized it was something more. Since that is the last time she has gone to Anchored. That was 1.5 years ago. She has been doing a lot better. In that 1.5 years, she did get herself a job. She has been working over 1 year now at Hot Wing Cafe. She got herself an apartment with her child, who is now 4. She is a single mom. She did get her own car, her own place, and is now expecting again. Her father, who is the victim in this original case, is in jail himself, but her mother did confirm that they've had no further incidents. And she is only 21 years old, Your Honor. She has had a pretty overwhelming couple of years, but she does seem to have her feet under her just barely with this job and this house, and she's doing much better in terms of mental health. She does have 3 months left. I did talk to her about possibly doing some anger management. That is something she could do online, while her child is asleep. She could get that done reasonably, even with the pregnancy and with her child and all the responsibilities that go with that. And so if Your Honor would consider perhaps 8 weeks of anger management so that, she has the opportunity to prove, do something and make this right. I think, the risk of her remaining in jail, possibly giving birth in jail or having birth complications is significant here.
Okay, I will convert the FVIP to 8 weeks of anger management and reinstate her. Ms. Manuel, I encourage you to just go ahead and see to get that done. I don't want to see you back here. Actually, I'm going to make it 4 weeks of anger management as opposed to 8. So 4 weeks of anger management. And you'll be done, Ms. Manuel. So go ahead and knock that out so that we don't see you again, okay? All right. Good luck to you, ma'am.
Thank you.
Thank you, Judge.
Your Honor, that concludes my business, my big excuse.
Yes, have a good rest of your day, Officer Allen. I'll see you next time. Thank you.
Miss Allen, before you log out, oh, geez, I was trying to catch her. Okay, never mind.
Position number 10, Belcher.
Mr. McCloud. Okay.
Okay.
Travis C. Andrews.
And this was Ms. McLeod's case. Yes, what are we doing, with Mr. Belcher today?
This is going to be a negotiated plea, Your Honor.
Good morning, Mr. Belcher. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir.
Thank you. Yes, Ms. McConkey.
Yes, Your Honor. The state's recommendation for count 1 is 12 months served 36 days, credit for time served 18 days, balance probated, and stay away from 875 West Peachtree Street, Atlanta, SDET 40 hours community service. The state's recommendation for count 2 is 12 months concurrent with count 1 and a $300 fine. The state's recommendation for count 3 is 12 months concurrent with count 1, no further violent contact with Officer Christine Diane. The state's recommendation for count 4 is 12 months concurrent with count 1 and a $300 fine. I would ask that the court sound for Officer Christine Diane if she is on the Zoom, as well as ask the defense to stipulate to venue, factual basis, and identification for purposes of the plea.
Deanna is on the line. I wish you to address the court. Now is your opportunity. Yes, Ms. McLeod.
We stipulate to the venue and factual basis and all of the factors necessary for this plea.
Okay. Anything further?
Nothing further, Your Honor.
Okay. Mr. Belcher, it's my understanding that in case 24 CR 004268E, you wish to plead guilty to public indecency, 2 counts of willful obstruction of law enforcement officers and simple assault. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Yes, sir.
I'll accept the plea as negotiated, Mr. Belcher. Let's see, when you complete the terms, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't have to report to probation, okay?
Right.
All right. Good luck to you, sir.
Thank you, Your Honor.
Next, we will go to position number 5, Mr. Andrews.
It's my understanding that Mr. Andrews has been a DA transfer, so has that already been accomplished?
We don't know if the.
I have not received no order.
Right.
Ms. Falk or Ms. Mokaki, I'm sorry.
Well, actually,
any-
I was handling the transfer. So
okay.
yes, we did resend that transfer paperwork to the DA's office along with the other case that I had previously mentioned to Your Honor, where we had resent the paperwork. I believe that was Mr. Harper. So we resent the paperwork on both. Both have the same basis, which is they are repeat offender and recidivist under theft by shoplifting. And so we are still waiting. I would ask for a 1-week reset.
Okay.
The bond situation, Your Honor, on Mr. Andrews is that we've been trying to get hold of Pad, and we are now receiving some return phone calls, but we're playing phone tag with his social worker at Pad today, literally in the courtroom. So it's better than it was yesterday.
Okay, so do you have any objection to the reset to 7/23?
We can't object to the reset, Your Honor, that's fine, but if there's any way, we're trying to figure out this stable housing puzzle for him. It's not going to be appropriate for him to be at his mom's, but he does work. He works in restaurants. He can do all kinds of what they call either hosting work or back of the house work where there's dishwashing going on. He is very employable. If he simply is determined to stay on his meds, and if we need to, we can go to the breakout session. But he has the potential to be very stable. He could stay at Gateway. He could stay at shelters or a shelter in particular. He knows how to get his court notice. And,
Okay. Fine. Do you have a request of the court today?
yes, Your Honor, if even at this point where we haven't firmed everything up, if we could consider a signature bond today, that would be good. I've talked to him extensively today. I've talked to his mother. I think we're on the verge of having stable housing for him set up. But I think he's got enough gumption to get it on his own by going to Gateway.
It's
I'm
a
not-
1,500 pretrial services bond already. So I'm not sure what it would be reduced to beyond the signature through pretrial services.
It was set up as a requirement of his mother signing him out. She couldn't do that because he's not gonna live at home. That's what it was.
Okay, so
Sorry,
if you find him stable housing, Mr. McLean, I'm not inclined, well, I'm not inclined to just put him out. Did I set that bond and require him to have his mother sign him out?
Judge Law started off and you came into, I believe, last week and basically we're hoping, like we are, that we could get it all set up. So it's a slow process, but
You did set that bond, Judge.
Okay, I thought I remembered.
But what I'm saying is perhaps today is the day that we could take a chance on him because he sounds really good.
Well, I don't want to, and I think this was my concern to begin with, just to place him back out on the street without having any services. So I'm happy to, if you get him set up at PAD or wherever, just let the court know. I can reset him for Thursday so that you'll have more time to do that.
That works.
Ms. Falk?
Yes, Your Honor. The state's only concern is under SB 63, he's actually got two prior failure to appears in the last 5 years. So I'm not sure what we would be changing this bond to. SB 63 only allows us to, depending on the interpretation, either give a surety bond or give a pretrial services bond. He already has a pretrial services bond, so I'm not sure what we're amending it to. That would still be within the confines of the law.
It's my understanding that it was conditioned on his mother signing for him. So now he can still get the same pretrial bond, but it's going to be on the condition that he goes to Gateway or that, whatever Mr. McLean comes up with. So he's still going to have a pretrial bond.
Okay.
Right.
Okay.
Okay.
All right. And so we'll reset him for Thursday so you all can address it at that time. Okay.
Thank you.
Hopefully you will have gotten him a place to stay, and you can let whoever the judge is at that time know that what my concern was.
Exactly.
Okay.
Thank you.
All right. Good luck to you, Andrews.
Position number 45, Williams.
We just have an announcement for position 49, Miss Leland Yanes. It's just an announcement.
Okay.
2 days from now. See you in 2 days.
What's the announcement?
I'll see you in 42.
Yes, Honor, the amendment, well,
This way.
I would like to reset her 1 week, but in the meantime, change she has a signature bond through pretrial services with a parent or an adult co-signer, and I just need to change the co-signer name to her dad.
Okay. So as long as she has an appropriate person that can sign her out, I have no objection to that.
Okay. Should I send that to pretrial? The name of the co-signer? Because it's listed as her brother right now.
It's just gotta be.
You can send it to me just in case, but they're gonna get all of that when they release her. So if it just said adult, if the original order just said adult co-signer.
No, the original order has a different name on it.
Okay, you can send it to me, but they'll get that information from her also when she gets processed out. But you can send it to me too, just in case.
Okay, I'll send it to you.
Okay, thank you.
And then.
Position number 45, Mr. Williams.
Okay, conflict. Did you speak with him, Ms. McLeod?
I did, Your Honor.
And what are we doing with Mr. Williams today?
This is going to be a non-negotiated plea, Your Honor.
Great. Good morning, Mr. Williams. Oh, good afternoon now. Good afternoon, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can place your hand down. Yes, Ms. Falk.
Just what position we on?
Position
45. And if we could get the criminal history from pretrial services.
Thank you.
You said you said, which Williams is this? Taurus Williams or Andrew Williams?
Andrew Williams.
Okay, one moment. I have the wrong Andrew Williams. 1 second. Now, it looks like we have just 2 arrest cycles beginning in 2002. We have his last arrest, which is the case that's on the calendar. And his previous arrest that was in 2002 was in Cobb County, theft by conversion of lease rented personal property. He received first offender treatment on that case in 2002, and it looks like the case was sealed. Nothing to add, Your Honor.
Okay.
So, Your Honor, this happened on May 19th, 2024. At 1217 Metropolitan Parkway, officers arrived and spoke to Mr. Manon, who stated that the defendant and his twin brother, Taurus Williams, had stolen a 12-pack of beer from the location, as well as a So as well as some incense sticks. So essentially what happened is at the Chevron gas station, both individuals were hanging outside the store. And I just have to kind of go through this with both. So Mr. Taurus Williams then entered the store. Mr. Andrew Williams then entered the store. They were both asked to leave. The defendant number 1, who's Taurus Williams, then re-entered the store, grabbed the 12-pack of beer. Mr. Andrew Williams then re-entered the store, grabbed some incense sticks from the front display. Mr. Manon was on the phone with 911. At that point, Mr. Taurus Williams pushed Mr. Manon backwards, making him stumble back. The 2 brothers were then engaged in a verbal dispute with Mr. Manon, threatening him, pulling up their pants, aggressively approaching him with their hands clenched into fists and shouting at them. You couldn't hear what was on the video, but Mr. Manon said that Taurus Williams had a firearm in his waistband and stated, "I will kill you, motherfucker," to Mr. Manon, which caused Mr. Manon to be in fear. These charges were actually taken out as robbery charges and then bumped down to theft by shoplifting, simple battery against both parties, Mr. Andrew Williams and Mr. Taurus Williams, based upon the decision that this was not a robbery, but rather theft by shoplifting with an element of violence. For that reason, the state's recommendation is 12 months served 90 days, credit for time served 22 days. From June 25th of 2024, balance probated, stay away from the Chevron at 1217 Metropolitan Parkway, 40 hours of community service, $500 fine, as well as an anti-theft course. We are also asking for no further contact with Mr. Manon. Again, our recommendation is largely not based on the theft by shoplifting, but by the behavior of both Mr. Andrew and Taurus Williams working as parties to a crime with each other once Mr. Manon, who's the store owner, objected to them stealing his items. That's all for the state. We would like to sound from Mr. Manon, and we would ask the defense to stipulate to venue factual basis and identification for the purposes of this non-negotiated plea.
We do so stipulate.
Which one allegedly had the gun?
That would be Mr. Taurus Williams, not Mr. Andrew Williams.
And if Mr. Manon,
sorry, Your Honor.
Go ahead.
Oh, I was going to say Mr. Taurus Williams, based on his history and the fact that he did have a gun, has a different recommendation for Mr. Andrew Williams.
Mr. Manon is on the line and wishes to address the court. Now is your opportunity to do so. Yes, Ms. McLeod.
Yes, Your Honor, we are okay with the state's recommendation in every aspect except the amount of time. My client has already been in jail for 22 days, Your Honor. He has no significant criminal history, and he denies some of the allegations in the warrant, Your Honor. Given the fact that he's already spent 22 days, he has no significant criminal history, I would ask the court to allow the time that he's already served, which is the 22 days, to be the time, and then the rest of it can be on probation, as the state is suggesting with the anti-theft course and the community service. And of course, the no further contact with Mr. Manon.
And Your Honor, I will just say that the defendant may not have a lengthy history, but he did receive on 23 SC 189912. That case was pled down from an aggravated assault to a battery, where he received 12 months, served 290 days, balance of 75 days probated. That was based on an incident that occurred with, and let me just take a look at that accusation, the indictment. It was that he had allegedly hit someone with a wooden board and a tree branch. And again, that was pled down to a misdemeanor that was also in conjunction with Mr. Taurus Williams, who was the co-defendant in that case as well. So there's a history here with the two of them acting in conjunction that does concern the state, and that is the reason for the recommendation. And I will just add, he unsuccessfully was terminated on probation on that case, March 22nd of 2024.
Given the allegations, Ms. McLeod, I am inclined to accept the state's recommendation on the simple battery. I'm inclined to give him time served on the theft by shoplifting with all the other conditions. If that's what he wants to accept, then that will be the sentence of the court.
He'll accept that, Your Honor.
Yes.
Okay. Mr. Williams, it's my understanding that in case 24 CR 004472H, you wish to plead guilty to theft by shoplifting and simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept your plea, Mr. Williams, for the theft by shoplifting, 12 months to serve 44 days, credit for time served 22 days, balance probated, stay away from the Chevron on Metropolitan Parkway, 40 hours of community service, $500 fine, and an anti-theft course. For the simple battery, it'll be 12 months to serve 90 days, credit for time served 22 days, balance probated, concurrent with count 1, and no further contact with Mr. Manon. Once you complete the terms of the probation, it'll go to a non-reporting status. So once you get out, the sooner you get the terms done, the sooner you won't be on reporting probation, Mr. Williams. Good luck to you, sir.
Thank you, Your Honor. And Your Honor, that concludes my business before the court today. May I be excused?
Have a good rest of your day, Ms. McLeod.
Thank you. You too.
Next we have the other brother, position, Mr. Taurus Williams. I believe he's 46.
Okay. And who's representing?
I am, Your Honor.
And this is also a non-negotiated plea.
Yes, Your Honor.
Good afternoon, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. May I get the history, please?
Yep, 9 arrest cycles beginning in 2020. There's a misdemeanor conviction out of Fulton County for possession and use of drug-related objects. That's from February of 2020. There's an arrest for aggravated assault out of Fulton County. Arrest date was February 28th of 2021. There's no disposition listed on the GCIC for that case. There's another arrest out of Fulton County for February 9th of 2023 for aggravated stalking. One second. I'm sorry, it's a felony conviction. I apologize. Felony conviction out of Fulton County for aggravated stalking. Disposition date on that is June 21st of 2023. He received first offender treatment on that case, and he received 2 years and 245 days of probation on that case. Let's see. It's a violation of probation from 2024 and an FTA from 2024 as well. And he does have a hold for probation. Nothing to add, Your Honor.
Okay. Yes, Ms. Falk.
Yes, Your Honor. It looks like he's still serving time on first offender probation on that aggravated stalking, where he received 120 days in jail back on June 21st, 2023. That's also where the probation violation stems from. Let me just double check and make sure I'm correct on that. Yes, it appears that that's where the probation violation is also stemming from. The failure to appear was February 25th of 2024. That was based on his aggravated assault charge. That is the charge I referenced earlier that he shares with his brother. He has not resolved that case, and so it is still open under the 23 SC case. And let's see. He also, it looks like, had received 6 months in jail on that possession of marijuana less than an ounce case, which was actually pled down from possession of marijuana with intent to distribute, possession of drug-related objects under 20 SC 174539. He also had another conviction that was pled down from possession of marijuana with intent to distribute to possession of marijuana on 20 SC 174095. So he's had, let's see, at least 3 prior convictions. 1 is a felony, 2 were pled down from felonies, an open felony under the aggravated assault case under 23 SC 189912, and a probation violation, as well as a failure to appear. We've already heard the facts of this case, Your Honor. The part that this defendant played in it was he was the one who issued the threat to Mr. Manon. He did have a gun in his waistband. Mr. Manon said he did not pull the gun, but that, along with the threat, was very concerning for Mr. Manon, as well as he is the one who initiated the theft with coming in and taking the 12-pack of beer and then shoving Mr. Manon when Mr. Manon tried to prevent him from leaving and was calling the police. We did ask, based on his history, we are recommending 12 months served 180 days, credit for time served 22 days. That's from June 25th of 2024. Balance probated, stay away from the Chevron at 1217 Metropolitan Parkway, 40 hours of community service, a $500 fine, and anti-theft course. Count 2 is the same recommendation, 12 months served, 180 days, credit for time served. Concurrent with count 1, no further contact with Mr. Manon. Again, the reason for the recommendation is the difference between Mr. Taurus Williams and Andrew Williams is Mr. Taurus Williams does have a felony that he is currently under first offender on, has already violated, already has a petition for violation of probation, as well as he did have a gun on his person, threatened Mr. Manon, and pushed him as well. That's all for the state. We do ask the defense to stipulate to venue, factual basis, and identification for this purpose of this non-negotiated plea.
For that, just for my edification, Ms. Falk, is there a reason
Yes,
that
Your
he was not charged with possession of a firearm by a convicted felon?
By it would have been a first offender probationer. And let me see, I am not sure. What I will say is, again, the DA's office originally had this case as a robbery, and for whatever reason, determined that it did not meet their criteria and sent it to us.
Okay, thank you. Mr. Ty?
Yes, Your Honor. He does deny some of the allegations. Anything that's not in the warrant, which I don't see any mention of a gun in the warrant, Your Honor. But, I mean, he would be willing, we did talk, I mean, the state's requesting 180 days credit for time served, 22 days. I would just ask for him to have the same sentence as the co-defendant, his brother. 12 months probation, sentence to 90 days, credit for time served, 22 days. What you just heard, what you ordered for the brother. Stay away from the Chevron, 40 hours of community service, a $500 fine, an anti-theft course, and then for the simple battery, 90 days, credit for time served, 22 days. Concurrent with count 1, no further contact, stay away. And
Okay. Well, he's not in the same situation as his brother. His brother only had one other previous arrest charge. He's got numerous. I will do what I did for the theft by shoplifting. It will be 12 months to serve, 44 days, credit for time served, 22 days, with all the other conditions. Based on his history, I believe that is a fair recommendation from the state regarding the simple battery, given the allegations. So if that's what he wants to do, I'm willing to proceed.
no, Your Honor, I don't think he wants to proceed with 180 days.
Okay. Does he need to be arraigned this morning, or will you file a waiver?
I'll file a waiver of arraignment.
Okay. And let's see, Mr. Williams, your case will be returned to the division judge, and you'll get notification of your next hearing date, sir. Who do we have next?
Next is number 26, McCoy.
And this is going to be a bond modification request.
Yes, Your Honor. Your Honor did set that bond apparently on July the 1st. That was probably at first appearance, I'm guessing. I've conveyed the offer to him, and he is wanting to go to trial. The record of the arrest record I don't have, but he believes that he would be able to keep up with court dates if he were to have a signature bond.
Ms. Tyson, may I have the history, please? And will someone tell me what the current bond is?
Oh, it is $1,000, sure.
Okay.
11 arrest cycles beginning in 2004. No felony convictions. He has a misdemeanor conviction out of Clayton County for battery, a NOLO plea on that case, August of 2018. And his last arrest was January 31st, 2023 in Atlanta for criminal damage to property in the second degree, disorderly conduct, and criminal trespass. There's no disposition listed on the GCIC for that case, Your Honor. Nothing to add.
Ms. Falk?
Yes, Your Honor. I'm showing the disposition on the criminal damage to property. Let's see, in the second degree was actually, it looks like not presented to grand jury as criminal damage to property in the second degree, disorderly conduct and criminal trespass. That also involved the same victim in this case. We have had a chance to speak with Ms. Priscilla Dennis, who's the mother of the defendant. She stated that this is not the first time this has happened. This has been an ongoing incident. She and the defendant have multiple cases. We were able to see those cases, not only the 23 CP case that was dismissed, but he has convictions in 2021 and 2022, both for criminal trespass. One of them was actually, Your Honor, handled. It was 22 CR 00558-3Y. In that case, he was alleged to have had a criminal trespass against his mother. He was sentenced under that case and told to stay away from Nelms Avenue. Then their previous case was 22 CR 0, just make sure I have the right case numbers. 22 CR 005376Y. That was also a sentence by Your Honor on August 30th of 2022. Both were on the same date of different dates of offense, same date of sentence. And he was sentenced to, again, stay away from Nelms Avenue. There's also a 20, let's see. It just looks like the 21 CR may have had just a misprint and was put as 22, but it's actually a 21 CR case. So he does have two prior convictions, both involving his mother previously, both involving him going to the property and being told to stay away. This has happened again. She stated that the defendant needs help with mental health and ADET, and she does not want any contact with the defendant and wants him to stay absolutely away from her residence. So I'm not sure why this continues to occur. I mean, obviously, I think it may have something to do with the mother's recommendation for MH and ADET, but the defendant continues to go back on the property even after his mother has made it very clear, Ms. Dennis has made it very clear she does not want him at that location and wants him to stay away from her house. In this particular incident, this happened on, let's see, June 28th of 2024. In that incident, the defendant went back to the address at Nelms Road, Nelms Drive, and stated, according to Ms. Dennis, that the officer had actually been to that location earlier that day. This is actually the second time they went to that location. The first time he left soon after and then went back inside her home, attempted to take some peanut butter as she went to the mailbox to get her mail. He has not lived at that residence since 2015, does not have a key or any of his things in the house, and that while on scene the first time, the officer explained to Mr. McCoy he needed to leave the residence because he does not live there and cannot attempt to sleep on his mother's back porch. And as soon as the officer left, the defendant just went back to the residence. So this just is a recurring issue, Your Honor. And we ask that the bond remain as set. We're also going to ask for a social worker visit or an MHET.
Mr. McLean?
Nothing further, Your Honor.
Okay, well, I don't see that any circumstances have changed, so I'm going to leave the bond the same.
Understood.
All right. Good luck to you, Mr. McCoy. Your client has his hand up.
I'll talk to him at the visitation booth.
So his case being waived then?
I'm
Set for
right,
trial?
I'm right here in the building. I can go see him upstairs.
Then return to the division judge or to a division judge.
Position number 38, Seabrooks.
$38, so this is going to be a waiver.
On Seabrooks, yes, Your Honor, it's just a waiver.
Okay. Mr. Seabrooks, good afternoon. Your case will be returned to the division judge. You'll get notification of your next hearing date, sir.
Okay, I had a announcement that we set 1 week out, so it's gonna be returned.
Well, it could, yeah, the state, I think, was asking for 1 week out. Is that correct? Or am I thinking of the other person?
No, that's correct. The individuals at issue here were juveniles, and we wanted some more information to determine how we needed to proceed and if this needs to be referred to the DA's office.
We could, yeah, I mean, it could be there was no offer then, that we could reset it and see.
Okay, I'll put it on for next Tuesday.
Okay.
I do appreciate that. Thank you.
Sure.
Okay. Who do we have next?
Your Honor, if there's a gap in clients being available, I could make an announcement on positions 8 and 9. Ralph Autry, he does have felony court today, so he is not present, but I did just send yourself, our litigation managers, and Ms. Falk proof of his incarceration on the day he missed court. So I'm sorry, Ms. McKechnie, is this your client? I'm going to forward you this information.
No worries, Ms. Vigilante.
So he was in custody, in GDC custody on the day he missed court, December 13th, 2022. I have sent that to you all. I'll give you all a moment to review. And so I did speak with him. He gave me his permission to waive his presence today, plead him not guilty, and attempt to get this bench warrant set aside.
Those are special bonds. There's nothing.
And based on the information we received from Ms. Vigilante, it does look like he was in jail, so we would be okay with that bench warrant being set aside.
Okay, if you'll prepare that, Ms. Vigilante.
Of course. Thank you.
We know, Ms. Lewis, if Ms. Watson Cafe is going to be with us today or not. Have you heard from her?
Yes, I did hear from her. I sent her an email. She said that she was trying to find a colleague to assist her today to handle these cases, but apparently she must not, because I have not seen nobody pop up on her behalf.
Given that there's additional time requested, why don't we just go ahead and reset this week out?
Set it to the week after her leave is over with.
Yes.
In
Yeah,
which case?
Your Honor, she had emailed me and I had emailed her back to let her know that I would be able to do it for her, but I didn't hear anything else back from her. So I don't know if she did not receive this email. This was, I think, Friday.
Yeah, I did email her.
She was out of the country, but she did email me and I responded that I would take care of it for her, but I did not hear anything further.
Okay, so would you like to try to speak with Mr. Allen? The state's requesting a good amount of additional time on the case, so.
Well, I guess it could be reset then because there's no possibility of him getting out.
So Ms. Lewis, can we just reset it until her leave is up?
Be over on July the 22nd, so I can reset it that Tuesday.
Okay, what date is that?
That would be July the 23rd.
Okay,
And this is for positions 1 through 4, Joseph Allen.
yes. Let's see, did Maurice Carradine come on the line from the DV bench warrant calendar? Yes, I see Mr. Carradine there. Have you all had a chance to speak with him, Mr. Ty? Okay, you're on mute. I think that you said yes.
Yeah.
Yes, I have.
Okay, so can we take care of Mr. Carradine? Take it, Ms. Falk, that Mr. Carradine missed the court date?
Yes, Your Honor, that is correct. Let me just pull up that calendar and see which court date was missed. So if Your Honor will just give me a moment, I was switch tracking. And while I'm doing that, I do have a question on Mr. Autry's case. Although the bench warrant is lifted, Mr. Autry is going to remain in custody. He currently is on a no bond on multiple felony charges. So I'm not sure. I just will say that tends to pop back up when that happens. So I'm not sure how the defense would like to proceed with that case. If it's a jail jury reset, if it's just a waiver of arraignment, I'm not sure what the announcement would be on that.
Yeah, sorry about that. So he did give me permission to plead him not guilty, waive his presence and arraignment today. So we can send that along, and I'll be sure to let the division attorneys know that that failure to appear was set aside, and hopefully he will be receiving a bond today because he is in felony court right now.
Okay. And Your Honor, is this, let me just make sure I have the right case. I was looking at the wrong date.
He missed court before Judge Dixon on May the 9th, 2024. It was on a jury trial calendar. He was supposed to hire his own attorney.
Thank you.
Anything further, Ms. Falk?
Nothing, Your Honor, other than I am curious to hear what the reasoning was for him not appearing before court.
Okay, Mr. Ty.
Yes, Your Honor, he did not appear before court because he was in Douglas County. We had a traffic incident and was in Douglas County on May 9th. And I did confirm that. So he wasn't able to attend court because of that.
So he was in custody is what you're telling me?
Yes, well, he says that he was in court and then taken into custody.
Oh, okay.
Your Honor, I will say normally some proof of incarceration is provided that the state could at least review to confirm whether that is correct. Do we have any documentation?
I don't have access, and if I was doing this last night, to Douglas County records, but I just did a Google search and it showed that he was in custody in Douglas County on May 9th, 2024.
Ms. Vigiletti says that she will assist in
I have it printed out here.
Oh, okay. All right, so I normally allow, so it's not an issue with notice. So he received notice, at the proper address. Is that right? I just want to make sure.
Yes, Your Honor, his address hasn't changed. It is it's the same as what's in Odyssey, 3504 Fair Lane Court.
Okay, Mr. Carradine, I allow you to miss court on one occasion. If you miss court again, the bench warrant won't be set aside. You have to let people know if you were in custody, you should have followed up as soon as you found out that you were that you had missed court with someone, so that a bench warrant would not have been issued for you. But we'll set it aside on this one occasion. If you miss it again, we won't set it aside. Okay.
Okay.
All right. So if you'll prepare that, Ms. Ty, we'll get it signed.
Thank you.
Have a good day, Mr. Carradine.
All right, thank you.
Back on the SAP calendar, position 6 and 7, Ashley. What are we doing with Mr. Ashley today? And we also have positions 36 and 37.
I'm sorry, Your Honor, I can speak to what's happening with Mr. Ashley. I think he should be able to be present today, but I can give you an update as to what's going on. Mr. Ashley, very wisely, when I met with him, asked for some MH help. This incident arose from him attempting to 1013 himself at Emory because he knew he was unwell. I have reached out. He is already a member of PAD, so I reached out to them. They are coming tomorrow to do an assessment to up his level of care. Kasha, our social worker, has already met with him. She agrees with him that we can't release him until he gets some more significant help. And she has reached out to his caseworker at Grady. So it's really just a matter of those 3 social workers getting a better plan in place, because this was Mr. Ashley trying to get help. And as you can see, that did not end well. And so I never do this, but I know the state's not asking for additional jail time, but I do think we need to reset the case because we can't release him without a plan in place for preventing future incident.
What would you like to reset him until, Ms. Vigilante?
Perhaps a week, just because I don't know that it's reasonable to have a plan in place by Thursday.
Okay, so we'll reset him for 7/23. And it's my understanding that positions 36 and 37 that he has been released. Jacob Patrick.
Yes, Judge, he was released.
I think it just leaves us with position 2 and 3 on the add-on calendar, Shayla Owens.
Your Honor,
right?
she intends to be here today. I believe Deputy Milton is probably going to get her right now. That's probably why ACDC is quiet. And her family is also here. And so I do think we'll be ready to address that today.
So did I miss anyone? Is that everyone on the SAP calendar?
Yeah.
Okay. So if we can, while we're waiting on Ms. Owens, if we can go over the calendar.
All right, Judge, I'm gonna do my best here.
Okay.
On the probation revocation calendar, on position 1, it was commute to time served, case is closed. Position number 2, probations were reinstated, waived fees for 3 months, must complete evaluation in English management classes. Position number 3 was restated, probations were reinstated. Position number 9, same announcement, probation was reinstated, convert VIP class to 4 hours of English management. Position 5, same announcement, reinstate probation. Position number 6, reinstate probation. Position number 7, reinstate probation. And position number 8, commute to time served, case is closed. Position number 9, continue on probation, must enroll VIP class within 7 days from release. Report to 132 Mitchell Street for probation. In position 10, same announcement, continue on probation.
Ms. Lewis, can I ask you, I'm so sorry to interrupt. Can I ask you, do we need to submit any paperwork to convert that BARK class for Mr. Miles to a different animal class? Because I know that's a state program.
Whatever probation asks y'all to do, whatever paperwork, yeah, it goes through probation. It doesn't really come through us once they complete whatever probation needs from y'all to indicate that. Whatever
so if
she
she
said.
recommended it, then that's
Yeah.
probably okay.
Yeah, so I guess y'all, I don't know if it's a paperwork that comes from y'all to say, hey, this is converted to that condition. maybe she probably needs something like that. I couldn't speak on Miss Allen's behalf.
Got it. Okay, thank you.
Uh-huh. We're going back to the original counter. Position number one is position 1, 2, and 3, and 4 are all going to be reset to the SAP for next week for July the 23rd. Position number 5 is going to be an add-on for the SAP for July the 18th. Position 6 and 7 is going to be reset to SAP next Tuesday, July the 23rd. Position number 9, I will be receiving, position 9 and 10, yes, I will be receiving a waiver of arraignment, not guilty, reset for trial for the notice, and an FTA bench warrant set aside for position number 9. I'm sorry, that's 9 and 8, yeah. Number 10 was a plea. Position number 11, I have reset for SAP, July the 23rd. Position 12 was a plea. Position 13, what happened to Mr. Robert? He was released. The case is reset for the notice. Position 14, he was released also, Mr. Charles Evans. He's reset for the notice. Position 15, what are we doing?
Waiver,
That's gonna be a waiver, not guilty.
correct?
Reset for trial for the notice. Position 16 was a plea. Position 17 was NARPOS. I do need to receive the NARPOS on position 17, so the ASG, can you send that to me over at this time while we're in recess? Position number 8, I appreciate that, thank you. Position number 18, the bond was amended to a $2,000 pretrial level 2. And I'm assuming I'm receiving a waiver and reset further notice. Is that correct? I think that's Miss McLeod's case. I think she already did. She already did amended bond order. I don't think she did a waiver. So the bond is just amended. The case is just reset further notice. Position number 19 was a plea. Position number 20 and 21 was a plea. Position 22 is going to reset for trial for the notice. Both cases, 23 CR 0080771Y, which is not on the calendar, that one's going to also be reset for trial for the notice back to the original judge. Position 23, Hill, is a plea. Position 24, Ingram, was a non-negotiated plea. Position 25, Corey Jackson, was a non-negotiated plea. Position 26, waive arraignment, except for trial for the notice. Position 27, 28, 29, 30, 31, 32, all is going to be reset for trial for the notice returned to the original judge assignment. Position 33 and 34, what are we doing with Ms. Morrow?
Reset to 7/23 for some social work. We had gotten a request from somebody on that.
You said for social work?
Yes.
Okay.
Yeah, they're working on something. I don't know what.
Okay, so her case is going to be set to next Tuesday, July the 23rd. Position 35 was a plea. Position 36, and 37, defendants were released. Cases are reset for the notice. Position 38, I have a reset for SAP next Tuesday, July the 23rd. Position 39 was a plea. Position 40 and 41 was a plea. Well, 40 was a plea, 41 was a non-negotiated plea. I guess they're both non-negotiated. 42, who we have for? Oh, was a non-negotiated plea. Position, I also, yeah, just want to make sure I got that correct. Position 43, I received a null pros. Position 44 was a non-negotiated plea. Position 45 also was a non-negotiated plea. Position 46, waive arraignment, we set for trial for the notice. Position 47 was a plea. Position 48. What are we doing with her? Are we gonna receive a waiver arraignment? I know the bond hearing was denied for her. Latasha, right? 48? Are we getting if I'm getting a waiver arraignment for her? Or is she being reset to another court date? Y'all never said. Who had Natasha right?
That's Mr. Ty's case.
She's on the way back to the office. Check on that.
Ms. Lewis, I'm 99% sure this is gonna be a waiver of her arraignment, and if it's different, I'll shoot you an email. I'm gonna call Ms. Atai as soon as we get off court.
Yeah, because after y'all did deny the bond hearing, nothing was said after that, so.
Okay, I'll double check on that for you.
Okay, well, I put temporary waiver arraignment, not guilty,
Sounds good.
except for trial for the notice.
Yes, sir.
49, I guess we're supposed to get an amended bonding order that indicates that, I guess amend the name of the co-signer on there. And I guess it's reset for the notice. That's her case too also. Am I
Yes,
right?
but I did speak with her about that. I do know it was her intention to plead her not guilty, and she knows she needs to send you the bond modification.
Okay, okay.
Yes, sir.
And I think it's the name, because the name is indicated, the brother name is indicated on the bond order. It doesn't say adult, any adult co-signer. So I guess that needs to be amended. And on the add-on calendar, position number 1, which is Jeffrey Harper, is reset for the SAP for next Tuesday. And I guess we're holding on position 2 and 3, Owens. And I think that takes care of the counter. Any questions or corrections?
630.
Okay. And the DV case was reset, bond forfeiture set aside.
Yes.
I'm sure you remember Ms. Owens' case from Thursday. It was the case where you and me and Ms. Desiano came to an agreement, and I know Ms. Desiano's not here today. While we're waiting for Ms. Owens to come, should we all just make sure we're on the same page in a breakout room in case I need to relay any context to the state?
That would be fine with the state.
Okay, so if you'll put us in a breakout room, please.
And Owens family, I know you're here. Just hold on with us a few more minutes, okay?
I just crafted it, so I'm not gonna do it. Yes, sir.
Change 27. Oh.
No, sir. No, you don't have that.
Yeah.
No, sir.
When she done.
No, sir.
Where was she? Where they have her? Oh, medical. No. You going in the back.
I'll in the back.
Yep. B-A-R?
B-A-R, B is in boy.
We don't got him.
It might put on this. Oh, say you would. It happened to me earlier too.
Sit down, sit down and be quiet.
Oh, say you would.
No matter. Hey, we in court right now. This is court, so I'm gonna need y'all to hold it. No, it's somebody else. You know, give me this one, you want that I give it.
Oh, no, no,
Go ahead,
yes.
He said he was gonna be there on 12.
So, Pauline, Andrews, and Johnson, y'all gonna talk on the phone right here. What do you do? One at a time, ain't no order, just. And where's Greg? Greg and Stevens. No, I'm sorry, Greg, you're gonna talk on the phone to Stevens, I'm gonna talk to the young lady behind the TV.
So it is him.
Y'all got it? Yeah. So Stevens, you the only one going behind the TV. You Stevens, you gonna go behind the TV and talk to them. When this guy. Oh, when this guy. Come, matter of fact, come in this. And then y'all. No, when he finished. When he finished, the next person go to the phone. Next person go to the phone.
Press those B-R-A-T-T.
Will you come, please? Yeah. Two. Blair and.
No, I'm talking.
Blair and. Stalin. Okay. Blair and Stalin.
We're not going to go straight on.
They are as well.
Thank you.
Don't hang up, just put the phone down.
Yeah, put your phone down.
Yeah.
Don't hang up.
Just place it down. Come on. Stand next. Same thing. Once you finish, don't hang it up. Just place it down. Yes. These are the females. Maisha.
Yeah. Brian, you gonna get on the phone. You gonna get on the phone, because you just did. They don't care. I put the job. They're not guilty.
Yes. 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 Since 2000. Queens, New York. I came down for the Super Bowl and never went back. January 2000. Never went back. Yes, and I was 7 years ago. About 3 7. Yes. It's interviews that vary. Yes, Steve Robinson. Yes. I do manifest support for Harsco. It's a Harsco, HARSCO. Or you can say cleaner if they just change the name actually. And I'm a certified home inspector. So I do that on the weekends. For cleaner for about 2 years, about a year and a half. And as far as the home inspections, almost about the same actually, about maybe 2.5, 3 years. I've been doing home inspections. After it's pretty cool. If I say a high number, would that be 50 getting the signature bond?
No.
After taxes, I'm going home 70 grand. School truck rate. I can't even say some college hours. No, sir. No, sir. Yes. I have 2, 25 and 9. He lives with his mother when he lives. But I typically get him on the weekends.
Okay, we're still waiting for Ms. Shayla Owens to appear in ACDC. So as soon as she appears, we can move forward. Court be in recess until Ms. Owens appears. Ms. McLean, would you do the court a favor? Is there anyone in there with you, or deputies? And could you ask them to call ACDC to see if they are going to bring
They're all right here. ACDC needs to
I'm
go.
listening.
Yeah, she's listening.
I can hear you, Your Honor.
Okay. Thank you. Ms. Owens, I just want to make sure that ACDC knows that we're all waiting on them.
Oh, okay.
If you can just call for us, I'd appreciate it.
Excuse me, Judge Morrow,
Yes, Officer Milton.
are you waiting for Owens?
Yes.
Okay, I'm on my way to get her.
Okay, thank you.
Okay.
Your Honor, if I may, and could PD Vigiletti and ASG Makake come on for a moment? Okay, so I have a 1:30 that I have to step out for. I was going to ask ASG Makake to handle this plea for me in my stead. I know that this is a negotiated plea. Do you want me to put the plea recommendation back on the record, or does Ms. Lewis have the information and we can just proceed forward from here? Obviously, when the defendant comes into ACDC.
I mean, I have the information. It's just that we're gonna have to make an announcement on the record anyway, so.
So,
okay.
Would you like Ms. Makaki to put it on the record when?
Yeah, she can.
Yes, and I will put in the chat what we agreed to. Okay, so I put all of that in the chat. As soon as Ms. Makake says that she's received it, I would ask that I be excused at this time, Your Honor.
Okay, have a good afternoon, Ms. Falk. Thank you.
Thank you, Your Honor.
Excuse me, Your Honor, is that Shayla Owens?
Yes.
We're back. We're back. Have a seat.
Yes, good afternoon, Ms. Owens. I saw you last week. It's good to see you again. Can you raise your right hand for me, ma'am?
Your Honor, she's unable to because I have her coming back.
Oh, okay. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. I've had an opportunity to speak with Ms. Vigiletti and the state regarding your cases, and Ms. Vigiletti has worked a number of things out for you. Yes, Ms. McConkey.
Yes, the state's recommendation for the simple battery 24CR000490D is time served, and correct me if I'm wrong, but I believe she has served 134 days already. The state's recommendation for the simple battery and criminal trespass 24CR001039D is 12 months, balance suspended, comply with any medications that she is currently on or ordered to take, stay away from the incident location, no further contact with the victim, attend outpatient appointments at River's Edge. And I would just ask the defense to stipulate to venue, factual basis, and identification.
We do for the purposes of the plea. Ms. Owens, I just want to say it to you one more time and kind of human speak what we worked out. They're not asking for probation from you as long as you stay away from Tawanda Knighton, stay away from the address 4594 Heatherwood, have no firearms, agree to take your medication. And our social worker got you an appointment at River's Edge to adjust your medication because I know you don't like the one that you're on. That's on July 25th. So we can adjust it. We can get you something where you're feeling better on it. And so you have to just attend that appointment, and I will create an order where we'll release you right to your uncle, Thomas Grissom.
Ma'am,
Yes.
Ms. Vigiletti, this is Thomas Grissom. I am just want to let you know that at that location on Heatherwood, the person who is there is no longer, she had the conflict with it, no longer lives there at that residence. So she won't have any contact with the Knightons there at all.
Okay.
So okay.
Okay,
And
so
she
Tawanda Knighton has moved away?
Yes.
Okay.
Okay.
So do y'all keep it stay away in or no?
Yeah, let's leave the stay away in.
The location is owned by her while she was in custody, sir, Your Honor. Her grandfather, who she living with, passed away. That is her grandfather's house, and the bottom of it was being leased by the Knightons or whoever they were, and they were evicted for non-payment of rent since March. And that eviction just occurred here the first of this month. Her uncle, who is also here on the line, Leroy Owens, is in town and living is staying at that address. So there's no issue at that address. So I just want to let you guys know that.
Okay, so Ms. McConkey, if there's no objection from the state, given that the representation is that the victim no longer lives there, is it fine with the state if we take the stay away off?
Yeah, could we just do a one-time police escort, just make sure she's not there, and if she's not there, then the stay away can, of course, come on.
Ms. Vigiletti?
I'm sorry, I think I missed the request. A
A
one-time police escort just to make sure Tawanda is not there?
Yes, just to make sure the
Got
victim
it.
is not there.
Okay, so Mr. Grissom and Mr. Owens, I'll explain after, but if just one time law enforcement can come and confirm that she's gone, then we'll be all good.
Okay, and we'll put that in the order also. Okay, anything further before I take the plea?
I just wanted to ask, because her family is here, Ms. Owens, your family's so excited to have you home, but I do think they want to hear it from you. Are you willing to agree to these terms?
Yeah.
Okay. Did you, Mr. Owens and Mr. Grissom, have any other questions for Ms. Owens or before we move forward?
Okay, anything else from anyone before we?
I believe Mr. Owens is on mute and trying to speak.
Hello?
Yes, can,
We're glad that Sheila is agreeing to the terms that you have set up. And we will assist in a reconciliation in any way that we can. And we appreciate all that you're doing to help her to get back on her feet.
okay. And thank you all for being here this afternoon. We appreciate it. So, Ms. Owens, it's my understanding that in case 24 CR 000490D, you wish to plead guilty to simple battery, and in case 24 CR 001039D, you wish to plead guilty to simple battery and criminal trespass. Is that correct?
Yeah,
Is that a yes?
yes,
Are you under the influence of any drugs or alcohol this afternoon?
no, Your Honor.
You've been represented by Ms. Vigiletti. Are you satisfied with her representation?
Yes, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
I'm giving up my rights.
To a trial by jury. You have a right to a trial by jury on these charges. By pleading guilty to them, you're giving that right up. You won't have a trial by jury. You understand that?
Yes,
Has anyone forced you or coerced you to plead guilty?
no,
Okay. I'll accept the plea as negotiated, Ms. Owens. I wish you the best, ma'am. Good luck to you. And Mr. Thomas and Ms. Owens also.
Your Honor, excuse me.
Yes.
I have a question. Is someone gonna pick her up from 901 Rice Street?
Yes.
Yes.
Judge, I'll draft a release order, and because her entire family is in town, if you don't mind, I will put Mr. Grissom and Mr. Owens both in that order so she could be released to either.
Okay, what's wrong with the court? All right, good luck to you all.
Okay, what time would that release be?
That's up to you, Mr. Owens. I will get that submitted to the court today. And so as soon as it's on file with the jail, I will let you know, and then that's up to you all as soon as you can go get her, okay?
Okay, we'll pick her up as soon as possible. As soon as that release order is there.
You might want to call down there first, because I've got to get all these orders signed, and we have to get those to the court. I have court this afternoon in just another few minutes. So the jail probably won't get the paperwork until later this evening. So you might want to call down before you go to make sure that she's ready for release, okay?
Will do, as long as I have that phone number. I appreciate that, sir.
Okay, yes, very good. Okay, that completes the 9 o'clock calendar. You all have a good rest of your day. Thank you.
Thank you.
Mm-hmm.